Again, my name is Judge Turner. This is the appeal of PDL BioPharma, Inc. The hearing today is being recorded and live streamed via the Office of Tax Appeals YouTube channel. A copy of the recording will be available there. We have a hearing reporter today, Ms. Alonzo. To ensure we have an accurate record, we ask each person that speaks one at a time, avoid speaking over one another, saying to me in particular. Also speak clearly and loudly. We need you to, when needed, we may need to interrupt you so that the reporter can get a good, proper transcript of the hearing. After the hearing, an official hearing transcript will be produced, which will be available on the Office of Tax Appeals website. Our goal here today, just as a reminder, I know everyone's been here before, but our goal today here is just to get a clean and efficient hearing. Allow the parties to present their arguments and documentation in support of those arguments to establish a proper record on which our panel can make its decision. Each party will have an opportunity to be heard, so please wait your turn to present your side. Questions may be asked of you by the panel members. I think we have a witness today. Be aware you will be asked questions by the panel and opposing counsel. And with that, do we have any questions before we get going?
I do, Judge Turner.
Yes, ma'am.
In your minutes and order, you asked for a list of all the items that we discussed.
Yes,
today.
ma'am.
Would you like them now? Or-
Yes, if you wouldn't mind providing those. Let's see. You can just hand it to me. That's fine.
And also, does anybody need copies of our presentation?
Yes, if you could have each copy of one of those for each of us, that'd be great. Just to make sure everyone's got them. Looks like you have them as well. Perfect. Thank you. Thank you. Perfect. Safe treats. Did you get thusly? Thank you for that. I appreciate that very much. That'll be greatly assisting. Okay, so before we go on the record, a couple of things I wanted to get out of the way. Timing. So thank you all for getting here early today. I know we've had this scheduled a couple different times for today, so thank you all for accommodating our schedule. We are the only hearing today. We had scheduled this for about 4 hours based upon the time everyone wanted. That puts us sort of bumping up against lunch. My plan today is that we're going to proceed with appellant's presentation first, and then give or take, when questions are done, we'll take a short recess. So Ms. Alonzo can rest her fingers. We can all have a restroom break, and then we'll get back at it. And the plan is to finish up with respondents' testimony right at about lunch. We'll take a break for lunch for about 60 minutes, or right at 60 minutes, and hopefully be back at it pretty quick after around 1 o'clock. And then we'll proceed with, as we talked about, both sides getting another opportunity to present short presentation on their arguments with a close by appellant, any questions by the panel, and that'll be that. Any questions on timing?
No, you're right.
We good? Excellent. Okay. Ms. Alonzo, you ready to go? Excellent. Okay, so we're going on the record now. This is the appeal of PDL BioPharma, Inc., OTA case number 230312712. The date is Tuesday, June 23rd, 2026, and the time is 9:09 a.m. The hearing is being held in lovely Sacramento, California. I'm Judge Turner. I'll be the lead for purposes of conducting the hearing. My co-panelists, Judge Lambert and Judge Hosey, are equal participants in the hearing. You may get questions from them. They are also equal participants in the deliberation and ultimate determination of the outcome of the appeal. Parties, if you would please introduce yourself, starting with appellant.
Yes, Your Honor. Jeffrey M. Vesley from Pillsbury, Winthrop, Shaw, Pittman for appellant.
Annie Huang from Pillsbury, Winthrop, Shaw, Pittman for appellant.
Chris Stone from PDL.
Respondents.
Laura Wingert for Franchise Tax Board, respondent.
Matthew Miller for Franchise Tax Board, respondent.
Delinda Tamani, Franchise Tax Board, respondent.
Excellent. Welcome. Okay, a few more housekeeping items before we get to the meat of it. During the briefing process, respondent had conceded interest abatement on the accuracy-related penalty from May 5th, 2022 to January 31st, 2023, and rescinded their imposition of a large corporate understatement penalty. Do I have that right?
Yes, that's correct.
Perfect. In March of 2025, the parties have submitted a joint stipulation. I'm going to provide a summary of it, but to the extent that becomes an issue, obviously the written document controls the scope and nature of that stipulation. But the stipulation generally provided as follows. The parties on the appeal will include all issues, including the request for 25-137 relief, and that will be decided by the OTA in a single hearing, which we are participating in now. The appellant will not seek FTB's Section 25-137, seek relief from FTB's 25-137 committee. And finally, the NOL and R&D credit carryover issues are mechanical and computational in nature. The carryover amounts will be recomputed if necessary according to the decision rendered by the OTA on the appeal at issue. I have that summary generally correct?
Yes, the
Yes,
summary
Your
is correct.
Excellent. Then that stipulation of the parties will be entered in the record. Finally, post-conference minute orders. I want to resolve a couple of outstanding issues. First, appellant had requested that issue number 2 be rephrased to reflect the same issue being raised in appeal of Medivation, Inc., which happens to involve respondent and counsel for the appellant. The revised issue statement would read, whether by application of Revenue Tax Code sections 23036D1 and 23609, appellant is allowed to reduce its alternative minimum tax, AMT, liability using research credits. Any objection to the revision of our issue number 2 to that, to reflect that?
No objection.
Perfect. Then such will be it. With respect to the exhibits, appellant noticed that my tables that were included in the minutes and orders included two number 12s, but no number 11. I apologize for that. What I've done in the revised table is to take the 2 item 12s and make them 12A and 12B. So hopefully, given that there's 44 exhibits, it won't mess up any reflection of them. And then appellant had objected to respondent's exhibit C has been withdrawn. Respondent has submitted additional exhibits identified as L and M. L is certain legislative history, and M relates to certain FTB published instructions. Is there any objection by appellant to the introduction of those documents?
No. No objection.
Perfect, thank you.
Judge Turner, can I just say that from Ms. Swing, could you make sure your microphone is on and close to you, because I'm not sure we're hearing you on the stream.
Sure, I apologize.
Okay, thanks.
Thank you. Where was I? Oh, appellant has submitted additional exhibit 44, tables concerning the determination of reasonable approximation. Does respondent have any objection to the introduction of that
No
exhibit?
objections.
Perfect. Appellant's objection, respondents raising a new issue in their opening brief, has not been further articulated, and therefore we're going to deem it waived. Appellants, appellants have both submitted demonstrative aids for the hearing today. Is there any objection by either side as to those demonstrative aids?
No objections.
No objection.
Perfect. All right, so with all that out of the way, our issues today we're going to talk about are, first, whether amounts received pursuant to the license agreement between appellant and its licensees are classified under their California Code of Regulations Title 18, Section 25136-2B4 as non-marketing and marketing intangibles or as mixed intangibles. Secondly, the revised issue number 2, whether application of Revenue Tax Code Sections 23031D1 and 23609, appellant is allowed to reduce its alternative minimum tax, AMT, liability using research credits. And 3, whether appellant has established a basis to abate the accuracy-related penalty. Is any objection to the statements as I've read them? Did I miss
No,
anything?
you're right.
No objections.
Perfect. All right. So, briefed exhibits. Appellant has submitted exhibits 1 through 44 that are in the table that both of you have access to with the renumbering of 12, the two 12s to 12A and 12B. Without objection, I'm going to enter those exhibits into the record. Respondents submitted exhibits A through M. Appellants did not object to the admissibility of these exhibits, and therefore they'll be admitted into the record as well. Perfect. Witnesses. Appellant had indicated calling Mr. Stone, the CEO and Secretary of PDL BioPharma, as a witness. Is there any objection by the respondent to Mr. Stone testifying as a witness?
No objections.
Perfect. Mr. Stone, I'm going to place you under oath now so I don't forget about it later. So if you please raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Consider yourself sworn in for the remainder of the hearing. Just to be, as I had mentioned before, you will be subject to questioning by the panel as well as by a respondent. Wonderful. And Mr. Appellants, you may have the witness testify either in narrative form or by questions. Up to you. Yeah, I know you guys have done this before. Okay. Where am I? Oh, we're finally getting to the meat of it. Appellants, you had requested 60 minutes for your affirmative presentation, 15 minutes for witness testimony. You can use your 75 minutes however you wish, but we'll start with that. We'll have questions of the witness, either when he's completed testimony, if you do that at the end or during the time, we'll have questions, and the respondent will have the opportunity to question the witness. Any questions?
No, Your Honor.
I give it to you.
Yeah, Judge Turner, and may it please the panel, we are going to proceed through the issues and the sub-issues as the court indicated in the following order. We will be discussing, first of all, the mixed intangible versus the manufacturing intangible issue. We will then proceed after that with what we call sub-issue number 1. If it's a mixed intangible, whether appellant's sourcing methodology and the reasonable approximation method was appropriate. We will then proceed to sub-issue number 2. If it is a manufacturing intangible, is appellant entitled to Section 25-137 relief? We will then go to the accuracy-related penalty, whether the accuracy-related penalty should be abated for these years. And finally, we will close with whether appellant may reduce its AMT liability by using the research credits pursuant to Section 23036D. Ms. Wong is going to start with it. We will bounce back and forth on a few of these issues, but we will try not to confuse you too much on that thing. But I think if there's any questions, happy to answer them right now, but otherwise we're ready to roll.
Thank you. I think that sounds good.
Okay.
Good morning. Thank you for your time today. As Jeff just noted, I will be addressing the first issue of whether the license agreements for the Queen patents were mixed intangibles. And as appellant has demonstrated in its briefs, that the license agreements with Genentech were mixed intangibles. And I should know from the start, as a preliminary matter, the royalty payments that PDL received were not just from Genentech, but from other licensees.
We're going to, just real quick.
Oh, I'm sorry. I guess the same thing that Judge Lambert just noted. I need to move it closer to me.
The mic is your friend.
Okay. So, you know, as we noted in our briefs, that the license agreements were mixed intangibles, and even though we focus on Genentech, there were other licensees, but because Genentech's royalty payments were the majority or a significant portion of the revenue, the royalty revenues at issue, I think the parties have agreed we're just gonna, for ease of discussion, just focus on Genentech. So the Queen, I should say, first, I'm gonna kind of refer to our presentation here. So just a very, very brief background, because I know we talked about this in our briefs. But the Queen patents brought about revolutionary change in the biopharmaceutical industry by improving the safety and efficacy of drugs. And that is something that was recognized by everyone. But, going back before the Queen patents, early therapeutic antibodies were derived entirely from mice. However, when injected into patients, the immune system recognized these foreign mouse proteins and tried to clear them, which would affect the drug's effectiveness and cause harmful side effects. Over the years, researchers tried to use a combination of mouse and human antibodies, but they were not always successful. Then Carrie Queen came out with the idea that computer modeling could help researchers choose the exact part of a mouse antibody they could use to develop a human therapeutic. So, as I noted here on the slides, the Queen patents were basically a general method to humanize monoclonal antibodies for drugs. And humanized antibodies are the essential active ingredient in each of the pharmaceuticals licensed under the Queen patents. Now, I would like to turn to the regulations at issue here. Regulation 25136-2B4B states that a non-marketing and manufacturing intangible includes, but is not limited to, the license of a patent, copyright, trade secret to be used in manufacturing or other non-marketing process, where the value of the intangible lies predominantly in its use in such process. And I think the important word to focus on here is predominantly. Or as the respondent explained in 2010, in its permission, at a board hearing, FTB board meeting, requesting permission to proceed with the formal process for the regulations under 25136, it says that for non-marketing and manufacturing intangibles, the customer's use of the intangible lies predominantly in using the intangible in a manufacturing process. That's how they define non-marketing and manufacturing intangibles. So again, even back then, predominantly. The use was predominantly in the manufacturing process. Now, turning to Regulation 25136-2B4C, it states a mixed intangible includes, but is not limited to, the license of a patent, copyright, service mark, trademark, trade name, or trade secrets, where the value lies in both the marketing of goods, services, and other items described in subparagraph A, and in a manufacturing process or other non-marketing purpose as described in subparagraph B. So under mixed intangibles, it is both. You have both the marketing aspect of it and the manufacturing aspect of it. As appellant has demonstrated, and contrary to respondent's position, the value of the license agreements does not lie predominantly in the use of the Queen patents in a manufacturing process or other non-marketing process. So the first thing we must look at is the license agreement. If we look at appellant's Exhibit 6, which is the amended and restated patent license master agreement dated July 27, 2009, in section 2.01, it gives the Genentech, the licensee here, the right to make, have made, import, use, offer to sell, and sell licensed products in the territory. So it clearly states offer to sell and sell. And the territory here is defined as worldwide. So with these rights, Genentech was permitted to market and sell the licensed products throughout the world. In other words, without these rights, Genentech would have infringed on appellant's patents if it attempted to market or sell pharmaceuticals containing the Queen antibodies. Respondent would like to ignore Genentech's rights to offer to sell and sell because in their view, any such right is insignificant to Genentech or PDL. Respondent is wrong. While the license agreement included a right to make licensed products, Genentech was not acquiring a commercial manufacturing process. Genentech was already the world's leader in antibody manufacturing technology. It held a critical technology patent called the Kabili patents. As Exhibit 7 of appellant's exhibits states, Kabili concerns antibody technology, specifically claiming a method of producing antibodies using recombinant techniques. This technology has been instrumental in the creation of some of the first FDA-approved antibodies, including Herceptin, which is one of the drugs at issue here. And further, as noted by Dr. Holly Prentice in her testimony, her testimony supports this as well. In Exhibit 20, her original declaration is in Exhibit 22, and the supplemental is in Exhibit 32. But I should note that Dr. Prentice has a PhD in molecular biology, has almost 30 years of experience in biopharmaceutical industry. She's had extensive experience in research, development, and commercial stage programs. She also has been an expert witness on various aspects of the manufacturing process relating to the biopharmaceutical and biotech industries. So, what she testified to, she obviously has experience and knowledge. So what she testified to were these points. The impact of the humanization described in the Queen patents was to improve the safety and efficacy of therapeutic antibodies for patients. There are no specific instructions provided in the patent regarding the generation of antibody preparations beyond the cited literature references. Mouse, chimeric, humanized, and human antibodies are manufactured in the same general manner, and the standard platforms used across the industry are applicable to all types of antibodies. No additional information was needed or provided by the Queen patents to aid or instruct the manner of manufacture. The Queen patents added nothing new to the body of scientific expertise regarding the manufacture of antibodies. In fact, in Exhibit 22, paragraph 22, Dr. Prentice also quoted from the patent itself. It says, they can be, they being the antibodies, can be readily designed and manufactured utilizing various recombinant DNA techniques well known to those skilled in the art. She further stated or testified that the basic elements of the manufacturing process for therapeutic monoclonal antibodies have
Ms. Wang, sorry to interrupt. Could you please speak a little slower for the hearing reporter?
Sure.
Thank you.
Thank you. So the basic elements of the manufacturing process for therapeutic monoclonal antibodies have remained the same for decades. And in the patent itself, there is only one mention of the word manufacturing. And it is to state that the humanized antibodies can be manufactured utilizing various recombinant DNA techniques well known to those skilled in the art. In other words, the Queen technology described what the product, i.e. humanized antibody, should look like. It did not inform the manufacturing of that product, since the manufacturing technologies were already known in the art. And also, we should point out, because the respondent seems to have equated technology with manufacturing process, a couple of times in their briefs. But as Dr. Prentice explained, technology should not be equated to manufacturing process. They are not the same thing. And she explained that in Exhibit 32 in her supplemental declaration, paragraph 4. But going back to what else Dr. Prentice stated was that the actual production of the humanized antibodies involves standard recombinant protein expression and purification methods used in the pharmaceutical industry. And in the case of humanized antibodies, the resulting safety and efficacy are the value proposition that companies license with the Queen patents. Dr. Prentice then concludes that the predominant value of the Queen patents was not in its use in the manufacturing of pharmaceutical drugs. Rather, it was in its use in the marketing the drugs based on the improvements of safety and efficacy of the humanized monoclonal antibodies covered by the Queen patents. And I should say the reason why we emphasize all this is because what is being marketed, and I think we'll talk more about it later when we talk about the marketing of pharmaceutical drugs, but it is different from marketing anything else. And so in drugs, safety and efficacy is very important, obviously, because it is used to target diseases such as cancer, and it affects, it's not something that the average person would readily understand. But I want to emphasize this point by turning to Mr. Stone to ask him some questions. So, Mr. Stone, can you briefly explain your background?
Sure. I have an undergraduate degree in biochemistry from the University of Massachusetts and a JD from the George Washington University. I've worked in the biotechnology industry for, I guess, 36 years now, since 1990 when I passed the bar. I've done intellectual property licensing, patent prosecution, which is the process of obtaining patents. I've probably written 100 patent applications. I've been involved in many infringement litigation cases, as well as I couldn't even count the number of licenses that I've drafted or negotiated. As my career moved on, I also was involved, I became the general counsel of a publicly traded biotechnology company, which is BioPharma at the time. I was the chief compliance officer for the company as well. We had subsidiaries that sold hypertension drugs, and we had a subsidiary that sold cataract operation machines. So I was working closely with marketing and sales groups in terms of putting together their marketing materials to be compliant with FDA regulations. That's a brief summary of the last 36 years.
So thank you, Mr. Stone. So with that background and your knowledge and experience with various patents, can you please tell us what do the Queen patents cover?
The Queen patents essentially provide guidance for the design of an advanced antibody-based drug. They provide a series of parameters that can be followed to design the drug, which is then incorporated into a pharmaceutical product and becomes a superior drug. And the purpose was to improve the safety and efficacy of the drug.
And do you agree with Dr. Prentice that the patent does not describe any new commercial manufacturing process?
Yeah, there's really nothing in the Queen patent specification or the claims that provided anything new regarding a viable commercial manufacturing process. If it had, and Dr. Prentice goes through these steps, the steps of producing a biotechnology pharmaceutical product are very well known, the basic steps. And Queen didn't provide anything new in terms of those steps. The steps would be you obtain a cell line, a host cell. You put a specific amount of genetic material into that host cell that is the instructions to produce the protein drug. You then ferment the host cell, so there's fermentation techniques involved. There's media, it's fermentation media. As you get the product produced in the fermentation broth, then the next step would be purification. There's a lot of complexity to purification and concentration. And then finally, formulation in a way in which it can be used as a drug. Those are really the commercial manufacturing steps.
And did you see any of these steps in the patent?
They refer, like I said, to the general outline of steps that you would follow to produce an antibody-based drug. The patent statute requires that you describe how to make, use, and sell your drug in your patent application, but that doesn't mean that the property right that you're obtaining encompasses all of that. It encompasses what's new, and what's new here was an antibody that had improved characteristics over precursor drugs.
So, speaking of rights, what did, in the license agreement with Genentech, what rights did the agreement confer to Genentech?
Yeah, I'd refer right to Exhibit 6, and it's right there in the license agreement and in the license grant, and it's the right to make, have made, import, use, offer to sell, and sell licensed products.
And could any license agreement have granted solely the right to manufacture?
Yeah, it's a feature of the patent law that I think Benjamin Cardozo said that a patent is a bundle of sticks. And you can license each one of those sticks. You can license the right to make, you can license the right to have made, the right to sell, the right to use, and these rights are split up commonly in licensing practice. And in this case, what PDL did was gave all of those rights to Genentech for the purpose of marketing and selling their drugs.
And so, I mean, in relating to that, if I could ask you, what resource would PDL have if Genentech had manufactured the drugs with the queen antibodies but did not sell those drugs?
They would have had the full right to manufacture the drug and throw it in the trash can. They wouldn't have owed us anything. You know, what they owed us money for was selling the drug.
Okay, so then that goes to my next question. What does offer to sell mean to you?
Colloquially, I think it means the marketing and promoting of products to potential customers.
And I know we already talked about this, but just to emphasize the point, would you have expected Genentech to license from PDL a manufacturing process for antibodies?
Certainly not based on the Queen patents, because there's nothing in there that provides anything new regarding a commercially viable manufacturing process. As I mentioned, there's these various steps of commercial manufacturing, and Genentech was very good at all of those. In fact, far superior to PDL. Genentech had products on the market, PDL didn't. You know, if Genentech was going to license manufacturing technology, it seems doubtful they would have come to PDL.
And then, in speaking of manufacturing process, with the license agreement with PDL, did anyone at PDL ever know Genentech's manufacturing process for making these licensed antibodies?
No, absolutely not. I mean, those processes are highly, highly trade secret. They have to submit them to the FDA in terms of getting drug approval, and it is common practice and almost always followed that the FDA redacts those instructions from the public record. Commercial manufacturing processes are just, they're highly confidential.
And speaking of the manufacturing process, if the manufacturing process were the dominant value of the license agreements, would you expect the description to be included in the license?
Yeah, I mean, licensing attorneys try to match value to price and revenue. So if I'm a licensing attorney, I'm going to say, well, the value of this technology that we're providing you is in manufacturing. And if the other side says, yes, we agree to that, first of all, I think what we would do is make it very clear that it's a manufacturing process. And we'd probably attach an exhibit which says, this is the manufacturing process that we're being licensed, because presumably we both know what it is. And that prevents disputes down the road. You know, that's not something that exists in the PDL Genentech license. In addition, I think the real predominant value here was that they obtained a product with improved safety and efficacy. Safety and efficacy are the linchpins of approval at the FDA. They're also the linchpins of whether a doctor is going to prescribe a drug. When the medical affairs associates who are basically the marketing group they're the FDA compliant marketing group within a pharmaceutical company, when they go to a hospital, they tout the safety and efficacy of the drug. They say, this drug is safe, here's the clinical trials, here's the technical reports, here's our post-trial surveillance, and they go through all that, but it's safety and efficacy that sells the drugs. I mean, just to be, you know, if you wanted to be protected from smallpox, you have a choice. You can go get a vaccine for smallpox, or you could go back to the old method of being injected with a live smallpox molecule and hopefully you live. You're going to pick the vaccine. So, I mean, that's a very rough example, but the idea is the same. Doctors are very aware of the safety and efficacy of drugs, and the medical affairs community, within the corporations, will then go to these hospitals and doctors, and they will say, look, you should have this drug in your portfolio because this is how good it is.
So with what you said, why could Genentech not have marketed its drugs and touted the safety and efficacy of their drugs without the PDL license?
Well, they couldn't have marketed the efficacy of a queen antibody. They could have marketed a drug that wasn't a queen antibody, and they did. They had plenty of drugs that weren't queen antibodies. But they had to market, if they wanted to market and sell the queen antibody, they were going to tout the safety and efficacy of it, and that was the purpose of the queen invention.
Okay. And then last question here. So what was the payment structure of PDL's license agreement with Genentech?
It was based on net sales of licensed products.
And not on the manufacturing?
Yeah, so I mean, again, as a licensing attorney, trying to match value to what is transferred. So what the payment is matched with the value that's being provided. If we were providing value in a manufacturing process, I would, typically when I've been involved in those types of negotiations, we talk about, a per unit sale payment. A per unit manufactured payment. So for if they manufactured 1 million doses in a year, we'd get $1 million. It wouldn't be based on net sales. Net sales fluctuate. I mean, net sales fluctuate based on currency valuations. They fluctuate based on taxes. They fluctuate in a whole bunch of different characteristics, which aren't relevant to commercial manufacturing. And as a licensing attorney, I would want to make sure that the license itself matches the value received. So that in this case, it is based on net sales, and net sales because sales were really the purpose of the license and the purpose of producing these products.
Okay, thank you, Mr. Stone. I'd like to stop now and ask if respondent or the panel has any questions before I move on.
Respondent, you have any questions of the witness?
Thank you. I do have a few questions for Mr. Stone. So I just want to confirm that you stated Genentech prepared marketing materials for FDA consideration of the drugs.
Yeah, so marketing materials are typically reviewed by the FDA.
Okay, so are any of these marketing materials included in appellant's exhibits?
I'd have to defer to counsel.
They are not, but I have a question, but I won't ask it now. I don't want to interrupt your questioning.
Great.
Okay, and then, so I'm going to move on to my next question then. So the license grant clause does state, as Ms. Huang pointed out many times, Genentech was granted the right to make and have made, there's offer to sell and sell. So the right to make and have made, which are the first two verbs in this license grant clause, what does that refer to, if not manufacturing?
Well, it clearly refers to any level of making of the product, so it includes manufacturing, sure.
Thank you. That's all the questions I have right now.
Ms. Wong, you had a question?
Oh, I'm sorry, the question's not really for Mr. Stone, it's for Ms. Winger, but I can wait.
Perfect. Panel members, any questions of the witness? Ms. Hosey?
No questions from me at this time. Thank you.
Mr. Lambert, Judge Lambert?
I have no questions, thanks.
I don't as well, but I might come back to it.
Thank you.
Thank you. You may continue with your presentation.
Okay, thank you. Okay. As Mr. Stone testified, Section 3.08 of the license agreement requires that Genentech provide written sales, it is based on net sales. And in the license agreement, it requires that Genentech provide written sales report and royalty payments to PDL each quarter. As Section 3.09 requires Genentech to, it also requires Genentech to keep clear and accurate and complete records of its net sales for at least 3 years for each reporting period, and be subject to inspection. So all this supports appellant's position that the license agreements were mixed intangibles, as they included the rights to offer to sell, and then the revenues were based on the net sales of these licensed products. And also, as specifically provided in the license agreement, Genentech was permitted to market and sell the licensed products throughout the world. Appellant has explained during protest on an appeal how pharmaceutical products are marketed because it is important to understand how the license, it is an important part to understanding how the license agreements are mixed intangibles. Yet respondent has dismissed it all by saying that how pharmaceutical products are marketed is irrelevant. Respondent instead argues that marketing must fall within the meaning of 25136-2. However, the regulation does not define marketing. Moreover, Regulation 25136-2 does not require any particular form of marketing activities, neither does it exclude any particular form of marketing activities. Respondent also argues that the regulation does not carve out marketing for different industries, but respondent has pointed to no authority that requires the marketing of every industry to follow a strict definition. Respondent has also said that the green technology must be promoted on a pharmaceutical product somehow for it to qualify as marketing. In essence, respondent is requiring that the humanized antibodies covered by the Queen patents are described, labeled, or imprinted on the drug itself, and that no other action promoting or selling would qualify as marketing. This is clearly not the law. The definition of marketing is much broader than respondent is arguing on appeal. In Chief Counsel Ruling 2015-03, respondent cites the Oxford Dictionary definition that states, quote, marketing is defined as the action or business of promoting and selling products or services, including market research and advertising, end quote. First, I should note that we understand that respondent has argued that the Chief Counsel Ruling 2015-03 has been withdrawn by legal ruling 2022-01, and therefore cannot be relied upon in any way. However, respondent is not relying on the substantive discussion of the Chief Counsel ruling, but on the definition of marketing used by respondent's own Chief Counsel. Legal ruling 2022-01 does not say anything about that. So neither has respondent explained in this appeal how the Chief Counsel's reliance on the definition of marketing in the Oxford Dictionary is wrong. So back to the highly regulated nature of the pharmaceutical industry. Because of the scientific complexity of the products and the fact that the use of it could greatly affect one's health, marketing and selling in pharmaceuticals is very different from marketing and selling almost any other product. Generally, pharmaceuticals are marketed to the medical professionals who prescribe and or administer them to patients. They're basically if one way to look at it, they're the customers. And the primary reason, as Mr. Stone testified, a doctor might prescribe one pharmaceutical over another is whether it is the safest and the most effective for addressing the medical issue. The drug manufacturer would tout the benefits and advantages of certain components of their own drugs. And we show with our exhibits 9 through 21, all the various articles that talk about that. But this kind of information in terms of benefits and advantages of certain components of a manufacturer's drugs is not something that is advertised and marketed in a traditional sense. Physicians rely heavily on the safety and efficacy data provided in technical journals, clinical reports, and by medical affairs representatives within the pharmaceutical companies. And these medical affairs representatives, as we explained in our briefs, is usually people with PhDs in certain sciences, and so they can explain some of the components of the drugs and the safety and efficacy of them. But also, as Exhibit 17 explains, when highly innovative drugs are prescribed, safety and efficacy is of crucial importance. So also in Mr. Stone's testimony, as well as in his declaration, the benefits of the drugs are shared with doctors and hospitals via the following. These are not all-inclusive, but like medical affairs teams I just mentioned, clinical trials, medical literature, and scientific studies. In this case, Genentech's humanized antibody drugs have been wildly successful because the underlying humanized monoclonal antibodies provided the safety and efficacy sought by all physicians. These drugs provided treatments for various cancers. Without the license agreements with PDL, Genentech would not have been able to promote or market in its studies, medical literature, or through the medical affairs teams the safety and efficacy of its drugs due to the humanized monoclonal antibodies covered by the Queen patents. Genentech did not pay tremendous sums of royalties for simply a manufacturing process for the antibodies, a process which Genentech itself had developed, as evidenced by their very lucrative Cabilly patents. Instead, the license agreements gave Genentech the right to promote, market, and sell the safer and more effective humanized antibody-based drugs. In sum, the facts firmly demonstrate that the license agreements were mixed intangibles and not non-marketing and manufacturing intangibles, because the value of the license of the Queen patents to Genentech did not lie predominantly in its use in a manufacturing process.
Thank you. What I'd like to address now is sub-issue number 1, which is the reasonable approximation method that the appellant applied in this matter. And I think it's very important to reiterate a couple things. One, as has been shown here, we're talking about something that fits within the 4 corners of the definition of mixed intangible in the regulations. We're talking about make, have made, use, import, offer to sell, and sell. So we're not taking the position in this case that we have a marketing intangible per se. We're saying it's mixed. There is some. There was certainly some for manufacturing, also for the marketing piece of it. That's the part of it that I think respondent has failed to acknowledge throughout this case. So if we kind of go back and say, okay, what about this reasonable approximation? And the regulations, go through great detail about when it's appropriate to use a reasonable approximation. And indeed, there is one particular provision that says that the 25136-2A states that if the location of the use of the intangible is not determinable, the location of the use of the intangible property will be or shall be reasonably approximated.
Sorry to interrupt, Mr. Vesely. Could you please, I think they can't really hear you on the stream. Could you maybe move the microphone closer?
Sure, I'm sorry.
Okay, thanks.
So the regulations section that I think is worth kind of looking at, because this is really the core of why a reasonable approximation method, the one that the PDL used in this case, is appropriate. So regulation 25136-2D2A states that the location of the use of an intangible property is not determinable. The location of the use of that property shall be reasonably approximated. The regulation goes into, so what are some of the methods that you can use to reasonably approximate the location of the use? And a population ratio is the one that's most discussed in the regulations, and that's 25136-2B7 speaks of that, and speaks of some of the requirements there. First of all, what we have to have here is that while PDL was aware of Genentech making sales of Herceptin and some of the other licensed products overseas, in the United States, the license agreement specifically references both the royalties in those instances. Overseas sales was a 3% royalty. Within the United States, it was a ratcheted level of royalty. It was different numbers depending on volume. And that was all tied to net sales. What they didn't have, though, was a precise country-by-country amount that was sold in that country. So what we then was looking at and coming up with, well, how do we reasonably approximate what should be sourced to the state of California for sales factor purposes? And what was looked at is in the license agreement, there is a list of all the countries in which PDL had what we call patent protection. They had patents in these various countries. It's an exhibit to Exhibit 6, and it lists all these countries. And so we were looking at those. Why is that important? Well, it's important that if there is a sale by Genentech into one of those countries, PDL gets royalties, gets its net sales royalty of 3% because it's overseas. If the sale is in a country that PDL does not have patent protection, for example, China at this time, India, big populations there, and that's going to be important in a second, they did not get any royalties from that. So what we provided before the hearing, Exhibit 44, was a document that we had provided, or KPMG had provided during the audit back in 2019. So franchise tax boards had this exhibit for a long time. This exhibit's very important. If you look at it's a two-page exhibit. If you look at the first page of it, it lists the various drugs that in question here. These are all the various cancer drugs and things with, Herceptin's is listed there, Lucentis, Avastin, and about 6 drugs total. That first page goes through and shows that what was the royalty revenue of each of these drugs by year, 2013, 2014, 2015. It goes on, and you can see as it goes down, the amount of royalties that we're talking about here are somewhere between $360 million and $413 million in a year. All of those royalties go into PDL's business income. They also are the royalties that are going into the, what portion of those should go into the numerator of the sales factor here. The first page goes on and explains how you get to the numbers that go into the numerator, and it has a sourcing percentage. And the sourcing percentage per drug is approximately 4 to 5% if you go down the entire list there. The second page provides the support for that. And that page basically goes through and says, okay, let's take a look at the various countries where PDL had patent protection. And if you look at the list here, down at the bottom, and it goes through 2013, 14, and 15, it gives the populations of each of these countries. Why do we do that? Again, Regulation 25136-2, B7, says that if your population ratio should have a California numerator and should have a potential U.S. population denominator unless there is material use of the license in foreign countries. Material use in our particular instance is a sale. It's a sale of the drugs. That couldn't be any more material. That's why the countries are all listed. That's why all their populations are listed. The regulation says you add the population of those countries or geographic areas to the denominator of that fraction. That is exactly what we did in our case here. We basically took the population for California, which is shown on page 2 there, each year as the numerator, and the denominator was the U.S. population plus the countries in which we had patent protection. That ratio works out to be approximately 4 to 5%, as page 1 shows, for each of the drugs, like that. That is the ratio that we have put forth here as being the proper amount of royalties to source to California. Now, if we go further in all of this, we say, okay, well, what's the difference here that what we've got? Is this appropriate, what we're doing? Well, as Ms. Wong has indicated, what we have here is a mixed intangible. You could not have designed better language for a mixed intangible. It basically fits right in like a glove. To make, to offer to sell, to have made, to sell. It got both items there. Mixed intangible is that the value is essentially between the manufacturing and non-manufacturing and the mixed intangible and marketing, excuse me. I think one of the other provisions, which is a real interesting one in the regulations, which shows that there's a, I wouldn't call it a bias, but a slant towards marketing. And that actually is Regulation 25-136-2 D2C, where a license of intangible property includes a license of marketing intangibles and a license of non-marketing and manufacturing intangibles, and the fees are not separately stated in the contract. It shall be presumed that the licensing fees are paid entirely, not just in part, entirely, for the license of a marketing intangible. This is right in the regulation. We did not separately state how much of the license, the rates for royalties, et cetera, for the manufacturing side versus for the marketing side of it. That regulation is directly applicable. Now, I think the couple other things that I think are important here is that the same list of countries are in the license agreement that are in Exhibit 44. There may be an exception or two or whatever. What's interesting there, I said before, China and India are not listed. We didn't have patent protection there. Had we put in
All right, let's get back on the record. Apologies for the interruption. I've got it 45 minutes, got about 30 minutes left if you need it.
No problem. Sorry about my ineptitude here with the microphone. So as I was starting to say is that respondent's position in this matter, as opposed to the 4% of the total royalties being sourced to California under our reasonable approximation method, their approach is that 56 to 100% of the royalties should be sourced to California. And that is really sourced, sorry for that, sourced for one reason. They're focusing on the manufacturing sites here. If this was strictly a manufacturing intangible, that might be something you'd want to look at much closer. That's not what this is. This is a mixed intangible. And indeed, as Ms. Wong indicated, the royalties are paid as a percentage of net sales. They're not paid on the number of items that are actually manufactured. That's critical here. So I think this is a perfect segue into the next sub-issue that we have, frankly, and that is a question about unfair representation of our business activities in the state, Section 25-137 issue. So our position for these years, 2013 to 2015, is somewhat derivative on what happened in 2019 to 2012, 2009 to 2012, excuse me. In 2009 to 2012, PDL was also audited by the Franchise Tax Board. As you folks know, that's the cost performance years. That's not market-based sourcing years. They issued assessments, notice the proposed assessments that were in excess of $36 million in tax by sourcing the certain percentage of the royalties to California. We protested that on two bases. One, that we had no nexus in California. Indeed, PDL had no physical presence in California in 2009 to 12, and not in 2013 to 15 as well. Our second argument was that under the cost of performance rules, the greater proportion of the income-producing activity as measured by, by cost of performance was not in California. After numerous submissions and a protest hearing, the Franchise Tax Board protest officer came out with a decision withdrawing the notice of proposed assessment in their entirety, concluding that there was no nexus to tax PDL here. After we look at this and we go, that particular exhibit that we supplied was in 26. Exhibit 26 are the letters from the protest officer here. So our presence in California in 13 to 15 is the same. We didn't have any. So when you talk about now moving from a zero, essentially royalty percentage being deemed to be California, to 56 to 100%, on the theory that the Queen patents were based on manufacturing, we got a manufacturing intangible or non-marketing intangible. The Franchise Tax Board's position is focused on the presence of Genentech in California. All of a sudden, here we have a large percentage of the royalties being assigned to California because of that. Again, as noted by Ms. Wong, respondent has ignored the terms of the licensing agreement between PDL and Genentech. And again, fitting the mixed intangible definition like a glove. Okay. Respondent has ignored the fact that marketing rights were licensed by PDL to Genentech. That's an important fact here. Respondent has ignored the fact that PDL received royalties in issue from Genentech based on a percentage of the pharmaceutical drugs which were sold by Genentech. And contrary to respondent's position, the license was not just to make the pharmaceutical drugs, it was also to market and sell them. That's really why they paid so much money for this. So to go from sourcing 0% of the royalties in 2009 to 12 to 56 to 100% in 2013 to 15, where PDL has no physical presence again, and we have a situation that it sells the pharmaceutical drugs throughout the world. You look at this and you say, something's wrong with this picture here. That's what 25-137 is all about. It's all about looking at whether there are unfair representation of business activities in the state by the Franchise Tax Board. And when you actually add on the fact that we are in single sales factor land, that even exacerbates the problem more. So PDL's position is that 4% is a reasonable approximation of the royalties to be sourced to California. It is reasonable in view of the license agreement. It's the fact the license itself was a mixed intangible. In light of the evidence in this case, including Dr. Prentice's testimony, and if you haven't read her declarations, you should read them. They are terrific. She is right on the money on this. And finally, the language of the patent itself. So the distortion percentages, if we want to play with percentages, go way, way, way beyond the General Mills 2 case of 8% in General Mills 2, where the Court of Appeal found distortion to exist. Ours is closer to 100%, depending on how you do the calculations. So in some, the NPAs just cannot be sustained for all the reasons set forth above here. Do I still have time, Your Honor? Yeah. Okay. I am going to move to the accuracy-related penalty next. Okay. Suffice it to say, it's our position that we believe that the penalty was erroneously imposed in this case. Section 19164 of the Revenue and Taxation Code incorporates Internal Revenue Code Section 6662 and provides for an accuracy-related penalty under certain circumstances. However, there are key provisions in the IRC, Internal Revenue Code, which reduce the understatement of the tax and thus the penalty itself. First, Section 6662 provides that the amount of the understatement is reduced by the portion of the understatement that is attributable to the tax treatment of any item by the taxpayer if there is or was substantial authority for such treatment. The substantial authority is further elaborated upon in the Treasury Regs 1.6662-4D, as in David, 3I. And there, the regs say the substantial authority for the tax treatment of an item if the weight of authority supporting the treatment by the taxpayer is substantial in relation to the weight of authorities supporting the contrary treatment. I would submit what we've got here is we don't have a manufacturing intangible, which is the Franchise Tax Board's position. We have a mixed intangible. We're going from a 0% royalty percentage in 2009 into 12 up to 56 to 100%. I think the arguments that we've made here about reasonable approximation, about what the terms of the license agreement are, all provide the substantial authority along with the expert testimony of Dr. Prentice. The second way you would reduce the penalty is Section 6662 D2B II, which provides in pertinent part that the amount of the understatement is reduced by the portion of that is attributable to any item if the relevant facts affecting the taxes treatment of that item are adequately disclosed on the return or in a statement attached to the return. And B, if there's a reasonable basis for the treatment of such item by the taxpayers. The third way you would reduce the penalty is that Section 6664C1, which provides in pertinent part that no penalty shall be imposed under 6662 on any portion of an underpayment if it is shown that there was reasonable cause for such portion and the taxpayer acted in good faith with regard to that portion. Well, you take those three items, they're about reducing the penalty, and we meet them all. Appellant's treatment of the license agreements as fixed mixed intangibles is fully supported by the specific language of the license agreements themselves, and in particular, the rights which PDL granted to Genentech, the right to make, have made, import, use, offer to sell those licensed products, as well as the definition of mixed intangibles in the regulations. It's also supported by the expert testimony of Dr. Prentice, where her conclusion in her second declaration, the predominant value of the Queen patents was not in their use in manufacturing pharmaceutical drugs. Respondent's position that the license agreements are non-marketing and manufacturing intangibles is contrary to the facts, Dr. Prentice's expert testimony, the plain language of Section 2.1 of the license agreement, and the plain language of the Queen patent itself. One mention of manufacturing in that patent, and that's 339 pages, and it's one paragraph. Is that really the predominant value of that patent? Respondent's attempt to source 56 to 100% of our royalty revenues to California is contrary to the evidence in this case and is based on the position that the license agreements are non-marketing and manufacturing intangibles, which is itself contrary to the facts and to Regulation 25136-2. Further, final point on this, respondent concluded, as I indicated in 2009 to 12, that there was no nexus for PDL, and basically zero royalties sourced to California. To go from that and to now to the position of 56 to 100%, much like the unfair apportionment argument here, this provides reasonable cause, good faith, you name it, all of the various criteria I've just mentioned in the Internal Revenue Code. The penalty just cannot stand. Thank you.
I have a few minutes.
You do.
Thank you, Judge Turner. So I will quickly go through the last issue, which is whether the research credit should be allowed to be used against appellant's AMT liability. And this issue, as noted in our briefs, is something that respondent has brought up over and over again. So 16 years ago in NASCO, and more recently in Appeal and Innovation. So the respondent is basically arguing that NASCO should be overturned and withdrawn. But we should point out that NASCO is a presidential decision, and despite respondents' objections to NASCO, the decision was reached after careful consideration of the parties' arguments. The SBE explained its decision in a 14-page formal opinion. And yet, respondent continues to argue that the State Board Equalization provided no justification for its determination that the word tax included AMT for purposes of Subdivision D. Again, 14-page opinion discussing the arguments by both parties. I should then, without belaboring the point, what we argued in the briefs, but the Court of Appeal in City Court versus FTB explained, the legislature has allocated to the State Board Equalization the power to hear and determine appeals of franchise tax matters. The agency's expertise in tax matters is not subject to dispute. However, respondent continues to dispute the expertise of the SBE and argues that NASCO should be withdrawn and overturned because the State Board Equalization made two fundamental errors: that the SBE found ambiguity in an unambiguous statute, and that having made that error, the SBE failed to apply the correct law to interpret that statute. I'd like to point out some case law. In Lundgren versus Dugmagen, the court explained that the plain meaning rule does not prohibit a court from determining the literal meaning of a statute, whether it comports with its purpose. And in Lewis versus Ryan, the Court of Appeal also explained that courts look to legislative history for clues of legislative intent. The respondent has repeatedly argued that there's no need to look at legislative history, despite what the courts have said, that you could look to it for intent. Also, all the arguments that respondent has made against the NASCO decision, it has made against the OTA's opinion in Appeal and Innovation. We understand that the FTB respondent has filed a petition for a hearing, and appellant has objected to it, and it is under consideration by the OTA. And so right now, but I'd just like to very quickly run through some points there. The OTA also, in the same way as they did in NASCO, respondent made the same arguments about legislative history, about the definition of tax, and in this case, and now here we are again. So this is fifth bite at the apple, if we were to count them. NASCO, the original hearing in the briefs, the petition for a hearing, Appeal and Innovation in the original, and now the petition for Appeal and Innovation. And now here we are in PDL for the fifth time, the same exact arguments, nothing new, and we have to keep wasting resources of both the parties and the OTA. But with that said, while this case is separate from innovation, the issue of whether the research credit may be used to offset the AMT liability is exactly the same. And so, and as the OTA explained in its case, Appeal of Graham and Smith, a presidential decision, this dissatisfaction with the outcome of their appeal, an attempt to re-argue the same issues a second time, is not grounds for a rehearing. And yet, like I said, we're here for the 5th time. So going back, appellant's position is that the research credit could be used to offset the AMT. The legislative history supports it. The FTB's own AMT report in 1992 supports it. The legislative discussion about how there's some credits of overriding importance, that exceptions would be made to the general idea that AMT would not allow credits to be taken against it. And the FTB does not dispute all that. What we have here is they simply do not like NASCO, and now they don't like Medivation. But the law is very clear. What you have here is that the legislative history with our exhibits here, exhibits 33 to 43, is you have all the various discussions about how these credits could be taken against the AMT. And as recently as June 2024, it was stated that what was added, the latest the Advanced Strategic Aircraft credit, it specifically said the credit could be used against AMT. So that it was, we're in 26 now, so 2 years ago, 2 years ago, as recently as 2 years ago, the legislature specifically added another credit to that list of 23036D1, where it could be used against the AMT liability. And the FTB, for all the times it's been brought up, it's 1992 AMT report. That report was required by the legislature when we California, conformed and included, basically promulgated, also included AMT, the alternative minimum tax. And then the legislature tasked the FTB to come up with a report about how the AMT worked and its effects. And so after years of study, the respondent did issue its 1992 report, AMT report, in which it included very specifically that research credit, among other credits, could be used to offset the AMT. The FTB has never explained why its position, its litigating position now is different from what it said back in 1992 when AMT was first put in place and after the research credits was included under 23036D1. So like I said, with the leg history, with AMT, the respondent's own 1992 report, the legislature's discussion about the overriding importance of some credits, including the research credit, the AMT, and also the NASCO decision, and with all that, respondent's position that the credits cannot be used against the AMT is simply wrong. And I think we have supported with in our briefs, with the exhibits, in our discussions, that appellants should be allowed to use its research credits against the AMT liability. And so I'll just quickly summarize the points, and then we will be done. So the main issues here is obviously the license agreements with Genentech that PDL had with Genentech were mixed intangibles, because the license agreement specifically said to make, to have made, offer to sell, to sell. Those are words that cannot be ignored. As Ms. Winger mentioned, in her question to Mr. Stone about, well, what does it mean to have to make? Well, I would like to ask, what does it mean to have offer to sell and to sell? Those words are equally in the same license agreement. The order of those words has no relevance. There's no emphasis on one or the other just because one word comes before the other. And so appellant has demonstrated that the license agreements were mixed intangibles and that appellant's sourcing methodology was reasonably approximated with the California over in the numerator and the population of the countries in which PDL had patent protection in the denominator. And as Mr. Vesely said, that is a very conservative way to calculate the ratio. And then 25-137 relief, as Mr. Vesely explained, should be granted as well. The ARP should be abated. And lastly, the research credit should be allowed to reduce AMT liability. So for all the arguments that we have made currently and also in our briefs. Thank you.
Thank you very much. Questions of the panel, Judge Hosey?
No questions from me at this time. I appreciate your presentation and your testimony today. Thank you.
Judge Lambert?
I have no questions, thanks.
I want to start, I guess, back at the premise, which is the question of what the predominant value of the patent license is. What's predominant mean, or predominantly, I think both words are used. What does that mean? How are we supposed to evaluate when a license for a patent that has arguably value attributed to both categorizations of marketing versus non-marketing manufacturing? How are we supposed to evaluate when one is predominantly of greater value than the other? Yeah.
Okay.
Or whoever on your panel would like to answer the question.
Sure.
Sorry.
Thank you, Judge Turner. If I could, if you don't mind, me reading back to you the question to make sure I understood it, is you're asking what does predominantly mean if the license agreement has both, seems to have both the values of marketing and manufacturing
Let me
rights?
see if I can say it this way. We have a categorization question, right?
Right.
Question is this license of a patent under the reg marketing intangible, a non-marketing manufacturing intangible, or both? I guess our first question is the ambiguity of what controls. It says if it's predominantly marketing, it's marketing. If it's predominantly non-marketing manufacturing, it's non-marketing manufacturing, or it's both. They're not mutually exclusive. So how are we supposed to evaluate which category of the three apply? If you can attach value, here's an example. We can have a value that's qualitative. I mean, it's quantitative. If 99% of the value is in one versus the other, is that predominantly? Or is it 50-50 or 51-49, right? So that would be a quantitative way of evaluating what predominantly means. And then the question becomes, what's that percentage that tips it between one versus the other or into both, correct? And then the other question would be, or is it a qualitative analysis? Is it go to the nature of the value to the seller or to the buyer? That's my question.
And if thank you for clarifying it. I will address those questions, and of course, Mr. Vesely can jump in if he has any additions. But in terms of what predominantly means, and as you know, the regulation doesn't define it, and that is I think that is why you have the question, whether it's 99%, whether it's 51%. But in this case, I think, since we are not talking in the abstract, and we're talking about here in this appeal, is respondent has argued that anything besides the manufacturing part of it is inconsequential and insignificant. So in their view, the PDL Genentech license agreement is not 51%. And so, to answer for us, we agree that there is, as Mr. Stone said, there is certainly to make, right? So there is a manufacturing part of it, but the value to Genentech, who is the one who paid billions of dollars to PDL, was the ability to sell.
But
So-
you're not saying it's predominantly marketing, you're saying it's mixed.
We would say it's, if we had to say, we would say it's more than 50% marketing, because that's a value. We are not getting paid for the manufacturing, as Mr. Stone said. If they manufacture and sold not one unit of their drugs, they get nothing. Too bad for us. And all the sales were net sales. And as also Mr. Stone testified, it's net sales of currency fluctuations, net sales of taxes, like fluctuation in taxes, even in foreign countries. It's net sales. It is not dependent on the manufactured units. I mean, if something was purely manufacturing, then it would seem odd. You know, as also Mr. Stone testified with his experience with all the different kinds of licensing agreements. Manufacturing licenses would typically have a per unit manufacturer basis. They certainly wouldn't depend on currency fluctuations. They wouldn't depend on, you know, what they would receive, would not depend on that. Taxes paid to other countries, you know. And so I think in this case, are we saying it's 99%? I don't think we have to go there. I think we would say that the marketing aspect of it is more than 50%, but we're not saying that it is all marketing. You know, unlike Respondent, who basically has said in its briefs that it is an insignificant value. Anything other than manufacturing is insignificant. So I don't know if that answers your question, but qualitatively, you know, that's the quantitative part, and I think you mentioned qualitative. And so here, I would also ask the panel to consider that as well, and I think that is a good way to look at it. What was Genentech paying for, right? Ability to sell their products and tout the safety and efficacy of their drugs. As Mr. Stone testified, they had other drugs that did not use the clean antibodies.
Thank you. As a response to my question, I guess then I want to go from that, the categorization question now, to the apportionment question or the sourcing question, which is, as Mr. Vesely pointed out, the reg actually creates a presumption that if you have a mixed intangible, there's a presumption that the methodology for sourcing is that it's fully marketing. How do we get outside that presumption? Is it simply a matter of the agreement of the parties?
I think, Your Honor, a couple things that I would, first of all, add to what Ms. Wong said, because I think it's real important to read the language of the regulation. Very interestingly, the term predominantly is certainly not defined in the regulation. But it is used in two places. It's used in marketing intangible and in the non-marketing and manufacturing intangible, where the value is predominantly in the marketing, in the first one, or in the manufacturing non-marketing. Where it's missing is the mixed intangible definition. Now, because it's kind of hard. If you're going to say it's a mix between marketing and manufacturing, you can't have both be predominant, I don't think. So the definition of mixed intangible basically says that where the value lies both in the marketing of goods, services, or other items as described in A, and the manufacturing process or other non-marketing. So a mixed intangible doesn't require you to come up with which one's the predominant one. The only point about why we actually asked Dr. Prentice, for example, well, what do you think was the focus, the value? Where's the predominant value? She came out very explicitly. It's not in the manufacturing piece. We're not denying there is value for the manufacturing, but I don't think we have to go there any further. We have to just say if there is value in the two processes here, that is a mixed intangible under the definition in the regulation.
And I think that answers, from your perspective, the question on categorization. But if you read in subdivision C in terms of the apportionment, it says where the fees are paid in such instances not separately stated in the contract,
Right.
it shall be presumed that the license fees are entirely paid for a marketing intangible. So notwithstanding the fact that you acknowledge that there's value in the manufacturing
Right.
aspect of it, the regulation creates a presumption to be treated as marketing, and I want to know how to get beyond the presumption.
Well, I think that presumption is very interesting because, you know, it's talking about the separation, you know, separate statements about here's the manufacturing statement of value, whatever you want to call it, and the marketing side of the thing. So you have a mixed intangible. We did not have separate statements for the two rights being done. It was one package, as Mr. Stone said. The whole thing went. So that particular subdivision in the regs, I think is directly applicable. So if there's anything about where does the tie go in the runner here, that says it goes to marketing there. Certainly doesn't go to manufacturing. So how do you define predominant, to get back to your point before? I'm not sure there's an easy way of doing it other than maybe an Oxford dictionary, again, going through. The fact of the matter is, they didn't define it in here, and it's very interesting that mixed intangible doesn't get into that. If we're not a mixed intangible, I don't know when you got one, frankly.
Thank you. One last question.
Sure.
On the issue of relief under 25-137, I think you've gone through extensively the nature of the quantitative differential between your position and response position. Help me understand that qualitative aspect a little bit about, I mean, Microsoft talks about both qualitative and quantitative analysis under 25-137. Help me understand the perspective of appellant with respect to that. What's qualitatively different about this apportionment method versus one the respondent would require?
That's a fair question, Your Honor. I think the qualitative, I guess, is we're talking about the same patents, the same licenses like that, from one set of years to the next set of years. What changed between 2009 to 12 and 2013 to 15? The only thing that changed is the law. We went into market-based sourcing. However, you're now in market-based sourcing plus single sales factor. And we have no presence in the state. Okay. Now, we understand that the doing business rules also changed to go to an economic nexus. But isn't that kind of a backwards way of getting to economic nexus here? Of coming up with a sourcing that's tied to manufacturing sites of third parties, not the activities of PDL. PDL didn't do anything differently in California in 2013 to 15. They were still based in Nevada. They were prior to that. So qualitative, it's not really a different set of facts per se, but I think that this situation is that you really come back to just the pure language of 125-137. Is this an unfair representation of their business activities because it essentially ignores all the activities that are going outside the U.S., all the sales, which are generating the royalties in question, which are what we're including in income and what we're fighting about in the sales factor here. Distortion has always been something of an interesting thing. It's kind of like you know it when you see it. This one you know when you see. This doesn't make sense.
So one last follow-up on that then, as you mentioned, the big change would have been the move from cost performance to a market sourcing. Do you have any sense of what the purpose of moving to single sales factor and market sourcing was relative to the type of activities that are at issue here?
Well, I think it's no doubt what single sales factor was aimed to do. That was to get out-of-state companies to be paying more California tax and to be incentivizing companies in California to basically be paying less tax that way. When you put the combination of that with cost performance, I mean, I wasn't in the legislature at the time, but we've talked about it a lot in our practice, that the all or nothing rules of cost performance were always troublesome. And there could have been other ways to do this. Could have been done on a proportion basis. You didn't have to go, all or nothing rule like that. Market-based sourcing was another way of correcting the perceived problem. And in my view, I think that when it's a combination of those two with the single sales factor apportionment, puts tremendous amount of pressure on the sales factor, of course, and how do you source the receipts? And that's why if you're going to be looking at sourcing receipts and you're going to only focus on one aspect here, like the Franchise Tax Board has done, I think we've got a problem here, frankly, especially when the royalties were not paid based on manufacturing sites. That's not how they were paid.
Great. Thank you so much. That's all the questions I have. I'll go one more time to my panel members. Judge Hose, do you have any questions?
No questions at this time, thank you.
Okay, we are going to take a recess now for about 10 minutes to allow Ms. Alonso to stretch her fingers. And then we'll be back here. We'll be back here, let's call it 10 minutes. We can have a restroom break as well. And then we'll get back on with the respondent's presentation, all right? Excellent, thank you. We can start the, oh, sorry, my bad. And we're ready to go. Excellent. Welcome back from recess. We're going to go back on the record now. Start the live stream if it's not already going. Excellent. Just reiterate our plan. At this point, respondent's going to get their 60 minutes. And after questions, we will take a 1 hour break for lunch. If there's not any questions, then we'll proceed with respondent's testimony in chief. Thank you all for coming today.
Good morning. My name is Laura Wingert, representing Franchise Tax Board. With me are Delinda Tamani, Assistant Chief Counsel, and Matthew Miller, Attorney Supervisor. The primary issue in this appeal is whether royalty income pursuant to license agreements between Appellant and Genentech, Inc. constitutes sales from a non-marketing and manufacturing intangible, which I will refer to from here on as a manufacturing intangible. Other issues include whether appellant has established by clear and convincing evidence that Revenue and Taxation Code Section 25137 relief is warranted, whether respondent properly imposed the accuracy-related penalty, or ARP, on appellant, and whether alternative minimum tax, or AMT, can be reduced by research credits. My colleague, Mr. Miller, will present the argument for the AMT issue after me. First, I will discuss why the license of the Queen patents is a manufacturing, not a mixed intangible, including relevant law, proper assignment of the royalty receipts to the sales factor numerator under the manufacturing intangible rules, and appellant's improper assignment under the mixed intangible rules. Second, I will discuss
Ms.
why
Wingert,
appellant-
sorry to interrupt. Could you maybe move closer to the microphone?
Sure.
Thanks.
Second, I will discuss why appellant has not met its burden under Section 25137, followed by why the ARP was correctly imposed on appellant. The undisputed facts are that appellant was a biotechnology company headquartered in Incline Village, Nevada, in the business of managing a portfolio of patents and royalty assets. During the years at issue, appellant generated $441 to $589 million of royalty income from Genentech and other biotech companies via license agreements that gave licensees the right to use appellant's Queen Patents technology in the manufacture of their drugs. These drugs combat cancer, food allergies, and other immunological diseases. As relevant, the license agreements granted Genentech the right to make, have made, import, use, offer to sell, and sell licensed products. Appellant earned royalty income based on net sales by Genentech of the following 6 drugs: Herceptin, Xolair, Avastin, Lucentis, Perjeta, and Kadcyla. These drugs and what they treat are listed on this slide. This appeal focuses only on the royalty income from Genentech, which constitutes most of the total royalty income. For some background on the Queen patents, these patents were developed in California in the 1980s when appellant was headquartered in the Bay Area. On a simple level, the Queen patents covers technology for the humanization of antibodies employed in a finished product, such as the drugs mentioned. Directly from the language of the Queen patents itself, quote, "The present invention provides novel methods for preparing humanized immunoglobulin chains," end quote. As consistent, appellant's own past executive officers have described the Queen patents as containing internally developed technology that appellant licensed to various biotech and pharma companies for products like Xolair, and also methods and approaches by which you make substitutions to arrive at a so-called humanized antibody. For some background on licensee Genentech, Genentech was a biotech company headquartered in San Francisco, California. As relevant, Genentech had manufacturing locations in San Francisco, Vacaville, and Oceanside, California, with capabilities to mass produce the drugs, generating the royalty income for Appellant. Genentech also had one facility in Oregon that did not have the same manufacturing capability. For California corporate income tax purposes, Appellant assigned none of the hundreds of millions of royalty receipts to its sales factor numerator, resulting in zero apportioned income to California. The license of the Queen patents constitutes a manufacturing intangible because the value lies predominantly in the use of the Queen patents invention or the humanized antibodies in the manufacture of Genentech's drugs. As such, some royalty receipts must be assigned to the sales factor numerator to reflect where Genentech, Appellant's customer, used the intangible property in California. The relevant legal authorities unequivocally support respondents' determination. Sales from intangible property are governed by Revenue and Taxation Code Section 25136 and California Code of Regulations Section 25136-2. Section 25136 provides that sales from intangible property are in this state to the extent the property is used in this state. Use of intangible property in this state under Regulation 25136-2B9 means the location where the intangible property is employed by the taxpayer's customer or licensee. Regulation 25136-2B4 defines three categories of intangibles. 1, marketing intangible, which neither party argues. 2, manufacturing intangible. And 3, mixed intangible. A manufacturing intangible includes a license of a patent, copyright, or trade secret to be used in a manufacturing or other non-marketing process where the value of the intangible property lies predominantly in its use in such process. A mixed intangible is defined similarly, except the value lies in both the marketing of goods, services, and other items, and in the manufacturing process or other non-marketing purpose. Thus, a mixed intangible must have a marketing component in addition to a manufacturing or other non-marketing component. For sales factor purposes, each intangible category has its own assignment rules under Regulation 25136-2D2, which applies when a taxpayer has not divested of his ownership rights, as is the case in this appeal. The rules for each intangible property category must be applied in the order provided. I will discuss the assignment rules in detail later. The intangible at issue in this appeal is the license of the Queen patents. The definition of intangible property in Regulation 25136-2B6 includes licenses. The license of the Queen patents constitutes a manufacturing intangible because the predominant or primary value lies in Genentech being able to manufacture the drugs using the Queen patents invention. As mentioned previously, the license agreements gave Genentech the right to have made the licensed products using Appellant's patented technology. This right to make speaks to manufacturing the drugs by Genentech. Appellant contends manufacturing process, as used in the regulation, very narrowly refers to a manufacturing method or to improvements to the commercial manufacturing process of manufacturing those antibodies, citing to Christopher Stone's declaration. However, there is no basis for such a strict interpretation, as the regulation never defines a manufacturing intangible as a manufacturing method, nor associates it with improvements to the commercial manufacturing process. Rather, as argued by respondent and exemplified by the regulation examples, manufacturing process can simply refer to making a product using the intellectual property in the patent. Manufacturing in and of itself involves a process to make a finished product. As applied in this case, Genentech employs appellant's Queen Patents technology in its antibody drug manufacturing processes, from developing the right gene sequence to large-scale production of millions of antibody-producing clone cells. Thus, Genentech's right to use the Queen Patents technology in its drug manufacturing process is the predominant value. Example 4 in the regulation, involving a manufacturing intangible, parallels appellant's situation closely. In example 4, the license agreement between Appliance Corp. And Formula Corp. Grants Appliance Corp. The right to use Formula Corp.'s patent to manufacture and sell its appliances. Formula Corp. Receives royalty income from Appliance Corp. Based on a fixed percentage of the gross receipts from appliance sales. Given these facts, it is presumed the licensing fees are paid for the license of a manufacturing intangible. Analogously, the license agreements in this case permit Genentech the right to use the Queen Patents invention to manufacture and sell their drugs. Like Appliance Corp., Genentech must pay appellant a royalty equal to a percentage of the receipts from drug sales. Please note the example does not associate a manufacturing intangible with being a manufacturing method. Rather, it is sufficient that Appliance Corp. Employed the intellectual property under Formula Corp.'s patent in the creation of its appliances. This is the same situation here as Genentech employed the Queen Patents technology in the creation of its drugs. More importantly, any other value in addition to the manufacturing value of the license of the Queen Patents is minor and not predominant in any way. It is Genentech's right to use appellant's humanized antibody invention in the manufacture of their 6 drugs that is a predominant value resulting in the royalty income at issue. Simply put, without the license of the Queen Patents, Genentech would not have been able to create the drugs as they currently exist because the humanized antibody technology belonged to appellant. Otherwise, Genentech would have faced infringement suits by appellant if it had manufactured these drugs without the license agreements. Thus, the manufacturing value is unmistakably predominant over any other value. Although the royalty income earned by appellant is based on Genentech's sales of these drugs, the predominant value nevertheless lies in Genentech first being able to create these drugs using the Queen Patents technology. Like example 4, sales of appliances, or in this case the drugs, results in income to the licensor. However, the right to offer to sell and sell is still dwarfed by the manufacturing value, such that the license is a manufacturing intangible, not a mixed intangible. Furthermore, the license of the Queen Patents is not a mixed intangible because the marketing value, if any, is minimal compared to the manufacturing value. Appellant's argument that the predominant value of the license was in marketing the drugs using the improved safety and efficacy of the humanized antibodies covered by the Queen Patents is unavailing. The drugs containing the Queen Patents technology was not marketed in any way that can be evaluated from the license agreements. As admitted by appellant, there is no logo or trademark on the end product drugs such that consumers know they are taking a drug containing the humanized antibodies. This is because appellant did not grant Genentech the right to use any of appellant's registered trademarks or other identification methods of the Queen Patents, such as name or patent number on the drugs. Therefore, appellant could not market the Queen Patent technology as incorporated in the drugs in any way. Moreover, the marketing component of a mixed or marketing intangible is illustrated clearly in the rulemaking files example involving the license to place a cartoon character's image on a towel. The real value in this situation is the cartoon character, not the towel, because a cartoon character increases the towel's value in the marketplace over a plain towel. In contrast, no such marketing is present on Genentech's drugs. Additionally, example 7 of the regulation involving a mixed intangible presents an obvious contrast to appellant's situation. In example 7, the license agreement between Axle Corp and Biker Corp specifies the fees to be paid for 1. The right to produce the motor scooters using patented technology owned by Axle Corp, and 2, the right to sell the scooters by marketing the fact the scooters were manufactured using the special technology. As such, there are distinct activities, one of which is marketing, for Axle Corp to earn income from Biker Corp. This is not the case in appellant's situation, as the license agreements gave Genentech the right to produce the drugs using the Queen Patent's invention, but not the right to sell the drugs by marketing the fact the drugs were manufactured using the Queen Patent's technology. In other words, the license agreements grant Genentech a general right to offer to sell the drugs, but this is not in addition to any right to promoting or advertising appellant's invention in the final drugs created by Genentech. Overall, appellant has not proven the license of the Queen Patents has value in both marketing the Queen Patents technology in Genentech's drugs and also in manufacturing or other non-marketing purpose for it to be a mixed intangible. Even so, appellant persistently claims, quote, without the licensing agreements with appellant, Genentech would not have been able to promote or market, i.e. offer to sell, in studies, medical literature, or through their medical affairs teams, the safety and efficacy of its drugs due to the humanized antibodies provided by the Queen Patents without infringing on those patents, end quote. Appellant has not substantiated any of these claims with credible contemporaneous evidence. Appellant's numerous third-party articles, mostly describing the humanized antibody invention and Dr. Carrie Queen, are not evidence of marketing value in the license of the Queen Patents. At best, they are independent opinions or studies that have no relevance to appellant's claim that Genentech promoted the drugs using the Queen Patents invention to doctors. To the extent such evidence actually exists, this purported marketing value is still minor compared to the manufacturing value. Also, while doctors may determine which drugs target a patient's diagnosis better, it is the Food and Drug Administration, or FDA, that determines safety and efficacy of drugs through the new drug application, the vehicle through which drug sponsors propose a new pharmaceutical for sale and marketing in the United States. Once a drug passes FDA approval, doctors can prescribe the drugs to patients regardless of advertising by the drug manufacturers. Thus, appellant is correct that Genentech's drugs contain the humanized antibodies under the Queen Patents, but that is it. Appellant has failed to substantiate the value of the license of the Queen Patents was also in marketing the drugs utilizing the Queen Patents technology to doctors or in medical literature. Furthermore, the offer to sell language in the license grant clause likely arises from federal patent infringement law under United States Code Section 271E, which generally means to provide a third party with a description of the merchandise and the purchase price, citing 3D Systems versus Aerotech Labs. Thus, there is no evidence that the offer to sell language directly means to promote to doctors the safer and more effective drugs due to the humanized antibody technology in the drugs. If Genentech engaged in the activities claimed by appellant, Genentech acted on its own, not pursuant to the license agreements. Also, any reliance by appellant on determinations in prior audit cycles is misguided because different tax laws applied, and more importantly, each tax year stands on its own, citing Commissioner V. Sonnen. After the type of intangible property at issue is established, the next step is to determine the location of the use of the intangible property in this state for sales factor purposes under Regulation 25136-2D2. The assignment rules are summarized in detail on this slide. Generally, for all three intangible categories, the first rule is the contract terms or the taxpayer's books and records. And the second rule is reasonable approximation if the first rule is overcome or inapplicable. However, for a mixed intangible, assignment of receipts to the sales factor defaults to the rules for a marketing intangible if the fees to be paid for the marketing component and the manufacturing or other non-marketing component are not separately stated in the agreement. In this appeal, the license agreements do not separately state the fees, so the rules for a marketing intangible are relevant for appellant's position. Additionally, the main difference between the rules for a manufacturing intangible and a marketing intangible is that a manufacturing intangible bases assignment of receipts on manufacturing location, whereas a marketing intangible bases assignment on the location of the ultimate customers. In this case, appellant has improperly applied the assignment rules for a mixed intangible by defaulting to reasonable approximation, using the population of jurisdictions where appellant had patent protection. While the assignment rules for a mixed intangible do not require separately stated fees for the marketing component versus the manufacturing or other non-marketing component, as is the case in this appeal, the rules for a marketing intangible must be used in the order provided. The first rule of a marketing intangible involves the books and records of the taxpayer, not reasonable approximation. Appellant, who is in control of its records, should attempt to use data on the ultimate customers of the 6 drugs to assign royalty receipts to its sales factor numerator. Appellant has not explained why its books and records are insufficient. Moreover, Section 3.08 of the license agreement regarding reports specifies that Genentech provide appellant with written reports and royalty payments on a quarterly basis. These written reports must detail net sales of the licensed product on a country-by-country basis and net royalty due, among other information. Based on Section 3.08 alone, appellant has the data to determine ultimate customers on at least a country-by-country basis, such as for the United States, using its books and records. Also, the marketing intangible rules state that other data under reasonable approximation should reflect the relative usage of intangible property. Appellant's proposal of using California population over the population of all jurisdictions with patent protection does not reflect the relative usage of the intangible property, or in other words, where the ultimate customers are. For instance, jurisdictions with patent protection may not contain ultimate customers of Genentech's drugs at all or contain an insignificant amount. Most importantly, reasonable approximation requires a taxpayer to provide sufficient evidence demonstrating the intangible property was materially used outside the U.S., and that specific information is preferred over general information. Appellant has provided no evidence of material use in the jurisdictions with Queen Patents protection, nor specific information leading to that conclusion. Appellant has merely provided a calculation showing the populations of these jurisdictions. Ultimately, appellant's reasonable approximation is unsupported by the law. Respondents' determinations of tax are presumed to be correct, citing Appeal of Cookston. Assignment for a manufacturing intangible is based on location of use by the customer, which is where Genentech manufactured its drugs. Appellant provided to respondent quarterly royalty statements it received from Genentech, which constitute books and records of the taxpayer. As relevant, the royalty statements provided the amount of royalties generated from drugs manufactured within the U.S. versus without the U.S., among other details. From this information, Respondent assigned to the sales factor numerator royalty receipts associated with those drugs that could be traced to being manufactured in Genentech's California facilities. Genentech did not have facilities out of state that could commercially manufacture the drugs discussed. As a result, 100% of the royalty receipts from the sale of Perjeta, Capsila, and Lucentis were assigned to the sales factor numerator because these 3 drugs were entirely manufactured in California. However, 57 to 61%, reflecting quarterly averages, of royalty receipts from the sale of Avastin, Herceptin, and Xolair were assigned to the sales factor numerator because these 3 drugs were manufactured both within and without the U.S. Overall, respondent's methodology properly reflects where Genentech, appellant's customer, used the license of the Queen patents. Now I'd like to move on to the Section 25-137 issue. In a conference on January 9th, 2025, with both parties and the Office of Tax Appeals, appellant confirmed they would not provide additional briefing on the Section 25-137 issue and would limit the argument to that provided in their briefs. Via stipulation dated March 4th, 2025, both parties thereby agreed this matter would be decided in this hearing. The party invoking Section 25-137 has the burden to prove with clear and convincing evidence that the standard formula does not fairly represent the extent of the taxpayer's business activity in this state, and also that the proposed alternative is reasonable, citing Microsoft versus Franchise Tax Board. Appellant has not met its burden under Section 25-137 because appellant has not provided clear and convincing evidence or argument as to why the standard formula is not a fair representation of his business activity in this state. Appellant merely concludes an unfair amount of income is being assigned to California because respondent concluded that in 2009 to 2012, appellant had no nexus in California, yet respondent seeks in this appeal to source 56 to 100% of appellant's royalty revenues to California. I'd like to point out that respondent's determination in this appeal is independent of the determination in previous years because different tax laws applied prior to 2013. Mr. Vesley discussed the transition from physical presence to economic nexus, and also the transition from cost of performance rules to the market-based rules. And it's a change in this tax regime that really is driving the apportionment factor in this case. And then more importantly, each tax year stands on its own. Appellant had ample opportunity to develop their argument at all levels of controversy, but only provided conclusory statements. Therefore, Section 25-137 relief is not warranted in this case. Now I'd like to move on to the ARP issue. Respondent correctly imposed the ARP on appellant under Section 19164 for a substantial understatement of tax. Appellant assigned none of its almost $500 million in royalty receipts to the sales factor numerator, resulting in no income being apportioned to California and appellant paying the $800 minimum franchise tax. As a result, the understatement of tax on appellant's California Form 100 exceeded the lesser of 10% of the tax required to be shown, or $5 million. Moreover, while defenses are available to abate the ARP, appellant has established no valid defense. First, appellant has not demonstrated substantial authority for its position other than arguing the understatement was based on a mixed intangible categorization of the license of the Queen patents. However, even if the intangible at issue is a mixed intangible, appellant should have apportioned some, not none, of the royalty income to California. Second, appellant has not demonstrated adequate disclosure or a reasonable basis for its position. Appellant's mixed intangible position is contrary to law and not reflective of how appellant apportioned none of his income to California. Third, appellant has not demonstrated reasonable cause and good faith. As discussed extensively, the value of the license of the Queen patents was predominantly in the patented invention employed in the manufacture of Genentech's drugs. A reasonable taxpayer in the same position would have assigned some of the royalty receipts to California under the manufacturing intangible rules. Therefore, the ARP was correctly imposed on appellant. In conclusion, the license of the Queen patents constitutes a manufacturing intangible that generated approximately $500 million in royalty income for appellant during the years at issue. As such, respondent properly assigned the royalty receipts to the sales factor numerator based on the manufacturing location of the drugs. Additionally, appellant has not met its burden for Section 25-137 relief, and the ARP was correctly imposed on appellant. Thus, respondent respectfully requests the Office of Tax Appeals to sustain its determination on these issues. I'm now going to turn this over to Mr. Miller for discussion of the AMT issue.
Good morning, judges. I'll be presenting the issue of whether appellant may reduce its AMT liability in taxable year 2013 by utilizing the California Research Credit under Revenue and Taxation Code, Section 23609. I'll divide my presentation into 4 parts. First, I'll discuss the plain language of Sections 23609 and 23036. Second, I will discuss ambiguity. Third, I will discuss the BOE's presidential opinion and appeal of NOSCO Holdings Incorporated. And fourth, I'll discuss the correct legal analysis for determining the meaning of tax in subdivision D1 of Section 23036 only if the OTA first determines that it is ambiguous, which it should not. However, as a preliminary matter, I would like to address a couple of points raised by appellant in their presentation. Appellant mischaracterizes FTB's argument regarding NOSCO. FTB does not argue that BOE provides no justification in its 14-page opinion. FTB argues that BOE's justifications are without merit and the opinion is contrary to law. Also, it's not a matter of FTB simply not liking NOSCO, as appellant puts it. FTB's obligation is to correctly administer the Revenue and Taxation Code. FTB does not write the code or determine policy. That's up to the legislature. And here the code is unambiguous. According to the plain language of Sections 23609 and 23036, appellant may not utilize its research credit to reduce its AMT. This is consistent with the public policy underlying the AMT, that all taxpayers pay their fair share. Regarding appellant's reference to the appeal of Medivation, that is an ongoing appeal. There are multiple appeals pending with the OTA involving this issue, and to date, OTA has not published any opinion on the matter. Only the parties' arguments in this appeal are relevant to this appeal. With that, I'll turn to the plain language of Sections 23609 and 23036. Section 23609 provides, quote, for each taxable year beginning on or after January 1st, 1987, there shall be allowed as a credit against the tax as defined by Section 23036, an amount determined in accordance with Section 41 of the Internal Revenue Code relating to credit for increasing research activities, end quote. You'll note that in the plain language of this statute, the term tax is enclosed by quotation marks. This use of quotation marks is not incidental. Rather, the legislature is using a long-standing California legislative drafting methodology. The current manual used by the legislature is entitled Handbook on Legislative Drafting in California by Chris McKelly. The manual provides that a defined term should be enclosed by quotation marks to indicate it is a defined term in the code. This legislative practice of enclosing specifically defined terms with quotation marks is consistent with standard legal style guidelines, as outlined in the Elements of Style by Brian Garner. For good measure in Section 23609, the legislature specifically identifies the statutory definition of tax to which it is referring. It identifies, quote, tax as defined by Section 23036, end quote. Thus, according to the plain language of 23609, the taxpayer may utilize the California Research Credit to reduce its tax as defined by 23609. as defined by 23036. Turning to section 23036. It is at the beginning of Part 11 in Chapter 1, General Provisions and Definitions applicable to Part 11. According to the Legislative Council of California in its 1975 publication Legislative Drafting Manual, when a word is used in a sense other than its dictionary meaning, the use of a definition at the beginning of the law to which it applies is utilized to avoid repetition of a phrase. At the beginning of Part 11 is Chapter 1. The first statute contained in Article 2 of Chapter 1 is Section 23030. Section 23030 provides, quote, except where the context otherwise provides, the definitions given in this chapter govern the construction of this part, end quote. Thus, the definitions provided in Article 2 of Chapter 1 apply to all statutes contained in Part 11. Every term defined in Article 2 at Sections 23031 through 23551.5 is enclosed by quotation marks to designate them as defined terms with specific meanings for purposes of Part 11. This statutory construction is consistent with California's longstanding legislative drafting methodology regarding defined terms that I referenced. In taxable year 2013, Section 23036 contained 10 subdivisions, A through J. Only subdivisions A and B provide definitions to be used in Part 11. In contrast, subdivisions C through J provide for the operation and use of credits. Therefore, in determining what is meant by Section 23609 by the phrase, quote, tax as defined by Section 23036, end quote, we look to subdivisions A and B of Section 23036 only. The other subdivisions, including subdivision D, are necessarily irrelevant to interpreting the term tax for purposes of Section 23609 because they do not provide any definitions of the term tax. Subdivision A1 of Section 23036 defines the term tax for purposes of Part 11. You will note that the term tax is also enclosed by quotation marks, indicating that its subsequent use throughout Part 11 is understood to carry the meanings assigned by Subdivision A1, consistent with standard California legislative drafting methodology. Per Subdivision A1, in Part 11, the term tax includes 4 enumerated taxes: the corporation franchise tax, the corporation income tax, the tax on unrelated business taxable income of an exempt organization, and the corporation franchise and income taxes imposed on S corporations. Thus, whenever the term tax is used for purposes of Part 11, it means one or more of these enumerated taxes. Subdivision A2 provides for specific modifications to the definition of tax for purposes of Part 11, but only in the case of certain installment sales under Section 24667. Subdivision B clarifies that for purposes of administering specifically identified provisions contained in Part 10.2, tax has other meanings. Please note that Subdivision B includes AMT in the definition of tax for purposes of administering specifically identified provisions within Part 10.2. Please also note the legislature's deliberate use of the term also in Subdivision B. The legislature is clarifying that for purposes of administering certain provisions in Part 10.2, the term tax also includes AMT. If the term tax, as defined in Subdivision A1, included any of the taxes enumerated in Subdivision B, including the AMT, there would be no need to include the word also in Subdivision B. Thus, the legislature is making clear that for purposes of Part 11, the term tax only includes the 4 enumerated taxes identified in Subdivision A. Since Sections 23036 and 23609 are within Part 11, the use of the term tax in these statutes only includes these 4 taxes. Only for purposes of administering certain provisions in Part 10.2, does the term tax also include the AMT. In this slide, I provided an illustration of the plain language of Sections 23609 and 23036 when read together. When incorporating the proper definition in Section 23609, it reads, for taxable year beginning on or after January 1st, 1987, there shall be allowed as a credit against the corporation tax, the corporation income tax, the tax on unrelated business taxable income of an exempt organization, and the corporation franchise and income taxes imposed on S corporations, an amount determined in accordance with Section 41 of the Internal Revenue Code relating to credit for increasing research activities. In other words, the taxpayer may utilize the California Research Credit to reduce the 4 taxes identified in subdivision A1 of 23036. In this appeal, appellant asked the OTA to disregard the plain language of sections 23609 and 23036 and include AMT in the definition of tax for purposes of subdivision D1 of section 23036. Appellant bases its argument on NOSCO and carefully selected quotes in its briefs of legislative history of section 23036 and a single internal FTB document. Notably, appellant avoids any discussion of the plain language of section 23609, which unequivocally and unambiguously states that the research credit can only reduce tax as defined by section 23036. And the only definition of tax in section 23036 that can apply to section 23609 is the definition provided in subdivision A1, which defines tax for purposes of Part 11. According to the OTA's precedential opinion in Appeal of Pino, tax credits are a matter of legislative grace, and the taxpayer bears the burden of proving they are entitled to the tax credits they claim. Statutes granting tax credits are to be construed strictly against the taxpayer, with any doubts resolved in FTB's favor. Thus, appellant must establish that section 23609 provides for use of the research credit to reduce the AMT. However, appellant has not presented any such argument. Therefore, it cannot meet its burden of proving entitlement to the research credit against its AMT. Instead of addressing section 23609, appellant relies on a misreading of subdivision D1 of section 23036, which provides that a credit may not reduce the tax below the tentative minimum tax except for the credits listed in that subdivision. Subdivision D1D identifies the research credit as one of those credits. Notably, in subdivision D1, the term tax is enclosed by quotation marks to indicate the specific meaning of tax under subdivision A1. Using appellant's definition of tax, that is to include AMT, subdivision D1 would read, a credit may not reduce the AMT below the tentative minimum tax except for the 23 enumerated credits listed below. However, this misreading of subdivision D1 would render subdivision D1 nonsensical and inconsistent with the basic AMT calculation. The tentative minimum tax, or TMT, is a computation utilized to calculate a taxpayer's AMT. The TMT is equivalent to the minimum total tax a taxpayer must pay. That minimum tax can be paid with a taxpayer's regular tax, its AMT, or a combination of both. If a taxpayer's regular tax is greater than or equivalent to the TMT, it pays its tax balance using its regular tax alone. If its regular tax is less than the TMT calculation, it pays its tax balance by using AMT or a combination of regular tax and AMT. Thus, the AMT is the taxpayer's TMT minus its regular tax. The purpose of subdivision D1 of section 23036 is to provide a tax advantage to a corporate taxpayer who is able to reduce its regular tax using certain enumerated tax credits. Under subdivision A1, if a corporate taxpayer has credits that it can utilize to reduce its regular tax below its TMT, it must do so. It pays its regular tax plus the amount by which its TMT exceeds its regular tax liability. This difference is the taxpayer's AMT liability. If the taxpayer has an AMT liability, it will also generate the alternative minimum tax credit under section 23453, which it can carry forward to succeeding taxable years and utilize to reduce its regular tax in one or more of those succeeding years. On this slide, I use the acronym MTC to refer to the alternative minimum tax credit under section 23453. Take, for example, a taxpayer whose regular tax is $100, has a tax credit of $75 and a TMT calculation of $50. If the credit is one of the credits enumerated in subdivision D1 that can reduce taxpayers' TMT, it would reduce its $100 regular tax using the $75 credit. This would result in a regular tax of $25. However, because the $25 is less than the TMT calculation, the taxpayer would pay a $25 AMT, so that it pays total tax equivalent to its TMT calculation. However, it would also generate a $25 alternative minimum tax credit of $25 that it can carry forward for use against its regular tax in future years. On the other hand, let's say the $75 credit is not one of the enumerated credits in subdivision D1 of section 23036. That taxpayer would not be able to reduce its regular tax below its TMT using this credit. Therefore, it would only be able to utilize $50 of the credit to reduce its regular tax to its TMT of $50. Since it paid no AMT, it would not generate an alternative minimum tax credit to carry forward to future years. However, it would be able to carry forward the remaining $25 of that credit to future years if that credit allowed for such a carry forward. As this panel is aware, some tax credits have expiration provisions, so if a taxpayer is unable to use its full credit in a particular year, it may lose the opportunity to do so after the tax credit expires. So for this taxpayer, there is no guarantee that it will be able to use that $25 credit carry forward in the future. Contrast that with the first taxpayer who was able to use the full $75 credit and also generated a $25 minimum tax credit. The minimum tax credit has no expiration date. Therefore, a taxpayer can carry it forward indefinitely. Thus, a taxpayer who is able to reduce its regular tax below its TMT using the credits enumerated in subdivision D is more likely to be able to fully monetize its credit before it expires, whereas a taxpayer with a credit not enumerated in subdivision D1 is less likely. Thus, subdivision D1 prioritizes use of certain credits to ensure that taxpayers are more likely to be able to monetize them before they expire. Turning now to the legal requirements for a finding of ambiguity and the lack of ambiguity within 23609 and subdivision D1 of 23036. Throughout this appeal, appellant has argued that subdivision D1 of 23036 is ambiguous based on NOSCO and selected legislative history of 23036. In Matei versus Corporate Management Solutions Incorporated, the California Court of Appeal notes the following well-settled principle of law. An ambiguity exists in a statute where a party can identify an alternative, semantically reasonable meaning of a statute. Throughout the proceedings in this appeal, appellant has failed to identify any alternative, semantically reasonable meaning of subdivision D1. When pressed to do so, essentially it has two responses. First and foremost, it argues that there is ambiguity because the BOE determined there is ambiguity in the NOSCO opinion. Second, it argues there is ambiguity because legislative history creates this ambiguity. However, its citation of legislative history to create ambiguity in the statute is inappropriate. In Monette versus San Francisco Board of Supervisors, the California Court of Appeal noted a well-settled principle of law. Extrinsic evidence, such as legislative history, cannot be used to both create and resolve ambiguity in a statute. However, appellant is employing the circular use of legislative history to both create ambiguity in section 23036 and resolve it, a methodology rejected by the Court of Appeal. Also, interpreting the term tax in subdivision D1 of section 23036 to mean something else than the four enumerated taxes of subdivision A1 renders subdivision A1 superfluous. If subdivision A1 defines the term tax for purposes of Part 11, and subdivision D1 is within Part 11, why does the definition of tax in subdivision A1 not apply to subdivision D1? Appellant doesn't answer this question. Appellant's interpretation is exactly the type of interpretation that is to be avoided according to the California Supreme Court. In Dynamet Incorporated versus Fair Employment and Housing Commission, the court held that courts must avoid the construction of terms in a statute that would render other parts of the statute superfluous. This leads to the BOE's opinion in NOSCO. Prior to the BOE's formal opinion in NOSCO, respondent maintained that only tax credits available to reduce a taxpayer's AMT liability were those whose statutes provided for such a reduction of AMT. Despite the plain language of Section 23036 in NOSCO, the BOE erroneously determined that ambiguity exists in the statute. Respondent's briefing in this appeal comprehensively discusses the incorrectness of the NOSCO opinion. I will not restate our arguments from our briefing, but I'm happy to answer any questions the panel may have regarding our analysis. Suffice to say that the BOE's opinion is contrary to law, and as a policy matter, it is entirely inconsistent with the purpose of the AMT provisions enacted by Congress in 1986 and by the California legislature in 1988. As the Senate Finance Committee stated in its 1986 bill analysis regarding the AMT, the ability of high-income individuals and highly profitable corporations to pay little or no tax undermines respect for the entire tax system and thus for the incentive provisions themselves. It is inherently unfair for high-income individuals and highly profitable corporations to pay little or no tax due to their ability to utilize various tax preferences. Yet this is exactly what appellant asked the OTA to allow it to do. It seeks to improperly use its research credit to eliminate $1,043,390 of AMT and pay no tax in taxable year 2013 based on NOSCO. However, the OTA is not bound by NOSCO for several reasons. First and foremost, the NOSCO opinion is limited to a taxpayer's use of the manufacturer's investment credit and the enterprise zone hiring credit, as noted in FTB Notice 2011-02. The opinion does not contain any analysis of the California research credit under Section 23609 or the proper interpretation of Section 23609 in conjunction with Section 23609's reference to, quote, tax as defined by Section 23036, end quote. NOSCO is distinguishable from this appeal and inapplicable to this appeal on that basis alone. Second, as detailed in FTB's briefing, the NOSCO opinion is contrary to law, and the OTA should not compound the BOE's error by expanding it to permit a corporate taxpayer to improperly use another credit to reduce its AMT. NOSCO was wrongly decided in 2010, and any decision predicated on its incorrect opinion, it would be wrongly decided today. Third, fundamentally, the NOSCO opinion is a determination of whether the BOE should grant a petition for rehearing on a particular matter. The primary opinion in NOSCO is a single-page summary opinion that did not provide the legal basis for the BOE's determination. Please see Respondent's Exhibit K for this summary opinion. The opinion on petition for rehearing is the first and only time in which the BOE explained the legal basis for its disposition in the NOSCO appeal. Therefore, FTB did not have the opportunity to even address the substantive analysis contained in the petition for rehearing. An opinion on petition for rehearing of a single-page summary opinion on whether two unrelated credits can reduce a taxpayer's AMT should not be used by the OTA as a basis for a determination on whether the California research credit can reduce a taxpayer's AMT. Fourth, at our pre-hearing conference, Judge Turner asked the parties to specifically address whether the judicial doctrine of stare decisis requires the OTA to issue an opinion consistent with the BOE's reasoning in NOSCO. It does not. As I previously noted, the NOSCO opinion is limited to a taxpayer's use of the manufacturer's investment credit and the enterprise zone hiring credit to reduce its AMT, and it is distinguishable from this appeal and inapplicable to this appeal on that basis alone. The OTA need not disturb the BOE's presidential opinion in NOSCO in order to find in favor of FTB in this appeal. Further, even if the OTA determines that NOSCO is applicable to this appeal, it is not bound by NOSCO. The OTA's rules for tax appeals explicitly grant the OTA with wide discretion to withdraw the presidential status of any previously presidential opinion within its jurisdiction, including those of the BOE, without reference to any limiting factors, including the principles of stare decisis. Rule 30503 grants OTA to the ability to withdraw in whole or in part the presidential status of an opinion including a BOE opinion. While the rules require OTA to publish a reason for removing the presidential status of an opinion and a notation on its website that the opinion is no longer presidential, there is no other limiting language, principles, or balancing tests required of the OTA. Thus, the OTA is afforded very broad authority to remove the presidential status of a previously presidential opinion in whole or in part, and it is not bound or limited by anything, including the analysis that would be required when determining whether to follow prior precedent under the principles of stare decisis. The broad authority afforded to the OTA in its determination of its own presidential authority is consistent with fundamental principles of administrative law. In Citicorp North America Incorporated versus Franchise Tax Board, which appellants also note or cite, the California Court of Appeals noted that adherence to an incorrect rule merely for the sake of consistency is not a virtue. In Weiss versus State Board of Equalization, the California Supreme Court affirmed the principle that due process permits an administrative agency like the OTA to deviate from stare decisis through adjudication. Hence, consistent with OTA's rules for tax appeals and court precedent, adjudicative agencies have broad discretion to overrule, in whole or in part, its precedent. This principle has been consistently affirmed by California courts, including instances of statutory interpretation. For example, in the Citicorp opinion, the Court of Appeal observed that an administrative agency may change its interpretation of a statute, rejecting a former interpretation in favor of a new one. Thus, the power of the OTA as an adjudicative agency to withdraw the presidential status of a previously presidential opinion is not limited or harnessed by the principles of stare decisis. Its discretion is unlimited in this regard, and as such, OTA at its election is free to look at the circumstances of the instant case without regard to the analysis in the underlying opinion in NOSCO, and in doing so, to use its broad power to withdraw in whole or in part the presidential status of NOSCO should it feel that the case had been wrongly decided. For example, the OTA could withdraw the presidential status as the entire opinion, or in the alternative, the OTA could withdraw the presidential status of NOSCO, as it pertains to its finding of ambiguity, but retain the presidential status as it pertains to the ability of a taxpayer to reduce its AMT using the manufacturer's investment credit and the enterprise zone hiring credit. Lastly, to the extent that the OTA wishes to consider the judicial doctrine of stare decisis, as the California Supreme Court noted in People versus Latimer, which is cited in both parties' briefings, the reasons for adhering to stare decisis are outweighed by the reasons for reconsidering and correcting an erroneous rule. Thus, stare decisis does not preclude the OTA from analyzing the correctness of the NOSCO opinion, and should the OTA do so, we are confident that the OTA will agree that the opinion is contrary to law and it is inconsistent with the plain language of 23036. Furthermore, it cannot be the basis for ignoring the plain language of 23609, which unambiguously and unequivocally states that the taxpayer can only utilize the California research credit to reduce tax as defined by Section 23036. Only if the OTA finds Section 23036 is ambiguous, which it should not, should the OTA engage in further statutory construction analysis. To analyze ambiguous statutory language, courts may consider extrinsic evidence to determine the meaning of a statute. The extrinsic evidence that a court may consider can be grouped into the following categories: administrative agency's interpretation, objectives to be achieved in the legislation, legislative history, public policy, and the statutory scheme of which the statute is a part. All this evidence weighs in favor of FTB's interpretation of Section 23036. Although FTB's interpretation has not been formally adopted in regulations, its interpretation is supported not only by the plain language of the statutes, but also by FTB's longstanding and consistent interpretation of the statute, as evidenced through FTB's published instructions and tax forms that date back to 1988. FTB's Exhibit M consists of copies of instructions of Form 100 insofar as it relates to AMT, as well as the relevant portion of Form 100 where taxpayers compute and report their AMT liability. These instructions and corresponding forms clearly set forth FTB's interpretation of the intent of Section 23036 by specifying which credits may reduce regular tax down to the TMT, which credits may reduce the regular tax below the TMT, and which credits may reduce AMT. I have already discussed the objectives to be achieved with the AMT, the public policy behind those objectives from Congress and the state legislature, and the statutory scheme as it relates to Part 11, the definitions for Part 11, and Sections 23036 and 23609 specifically. All of these factors support FTB's interpretation of Section 23036. As to legislative history, respondents submitted Exhibit L, which includes 137 pages of legislative history of Section 23036 from 1989 to present. Exhibit L includes every portion of the legislative history record that relates to the operation of Subdivision D1, including the portions that appellant previously cited in its briefs and the portions that it did not. We have identified the portions of the history related to the AMT, setting them off by red boxes in the exhibit. I should note that in its briefing and at the hearing today, appellant references FTB's presentation of preliminary findings from 1992 that it refers to as FTB's AMT report. However, this is merely an internal document from FTB, and it does not represent FTB's position then or now. It has never been FTB's position that the research credit can reduce a taxpayer's AMT, and appellant has not identified a single public statement by FTB indicating that this was ever its position. In fact, all published guidance to taxpayers indicate the opposite. Additionally, in its briefing, appellant referenced an individual letter from an assembly member to the governor regarding AB 802. However, legislative history must shed light on the collegial view of the legislature as a whole. In Quintano versus Mercury Casualty, the Supreme Court noted that statements of an individual legislature, including the author of the bill, are generally not considered in construing a statute, as the court's task is to ascertain the intent of the legislature as a whole in adopting a piece of legislation. In Halbert's Lumber Incorporated versus Lucky Stores Incorporated, the Court of Appeal stated that is the language of the statute that has been lobbied for and against, studied, proposed, drafted, restudied, redrafted, voted on in committee, amended, re-amended, analyzed, reanalyzed, and then voted on by two houses of the legislature. Such cannot be said about other documents that may make up a statute's legislative history. Several post-NOSCO bill analyses from the legislature from Exhibit L support FTB's interpretation of Subdivision D1. Today, I want to highlight two in particular.
If I could interrupt you.
Sure.
You've run at your 60 minutes. If I could
Okay.
get you to work at getting to
Sure.
the end of your
I've got
presentation.
about two more paragraphs, if you would indulge me,
Oh,
Judge.
sure.
I appreciate that.
Yeah,
Thank
no
you, I
worries at all.
appreciate it.
Yeah.
All right. In the analysis of AB 18339, the legislature explains that the credits enumerated in Subdivision D can only reduce regular tax below TMT, and the inability to reduce the regular tax below TMT using credits not identified in Subdivision D1 may prevent full monetization of those credits. This quotation is contained on page 116 of Exhibit L, and on page 126 of Exhibit L is the other quotation I have above. That is an important quotation because it really explains the operation of the statutes, which I went over earlier. In summary, respondent has established that sections 23609 and 23036 are unambiguous, and they do not permit an appellant to reduce its AMT liability by utilizing the California Research Credit. We've also explained the rationale for disregarding NOSCO or limiting its applicability to the credits at issue, and the OTA's authority for doing so. Accordingly, we request that the OTA hold that based on the plain language of sections 23609 and 23036, appellant may not utilize its research credit to reduce the AMT. And thank you. And at this time, we're happy to answer questions, but I think you're going to save those for after lunch, Judge?
I am going to do that.
Okay.
Good anticipation. So if it's okay, unless you have any quick summary to make on the entire presentation, what we're going to do is we're going to go to recess. We're going to take 60 minutes for lunch. We'll be back here. We'll call it 1 o'clock, at which time we'll have some questions for respondents. Does that sound good to everybody? Wonderful. Okay, we'll stand in recess until 1 p.m. We are going back on the record in the appeal of PDL BioPharma Inc. As you may recall, when we left off with the end of respondents' presentation, we were going to open the time for the panel to ask questions. So I will start with my panel members. Judge Hosey, do you have any questions for the respondent?
No questions for me. Thank you for your presentation.
Mr. Lambert, do you have any questions? Sorry, Judge Lambert, do you have any questions?
Yeah, I have a question. It's kind of going based off of what Judge Turner was talking about, but for FTB, in terms of what predominantly means, in the briefs, you mentioned the word incidental. I'm wondering if it means incidental, or do you define it as what the real value is, or what is FTB's definition of predominantly?
Thank you for the question, Judge Lambert. So the manufacturing intangible definition under Regulation 25136-2B4 uses the term predominantly, as does the marketing intangible definition. And so I argue today and in my briefs that predominantly means primarily. It is not defined, as Ms. Huang noted, in the regulation, but the plain meaning, common sense, common knowledge would be primarily, if we had to assign numbers, which are missing from the regulation, so it's a bit difficult, it would be over 50%. It is the primary, it's the primary value. And so our respondent's position is that the predominant value of the license of the Queen patents is in manufacturing these drugs using the Queen patents technologies. So these humanized antibodies. If there are no humanized antibodies, these drugs would not be created. They would not be the version that's on the market for sale that generated the royalty income for appellant.
Okay, I think that over 50%, it kind of doesn't make sense to me in a way, because how could you decide what's 50 versus 50%? That makes sense that predominantly means that way, but based on the way, the law is written and, with the predominantly language, it seems like kind of hard to tell what would be the difference between a mixed intangible and one that's in predominantly, because you could have 51% versus 49%, and they could both be part of the main purpose, but then according to you would be predominantly one way or the other?
So I really appreciate that question. It is a bit difficult. The rules between deciphering between a mixed and manufacturing, in this case, that's why the parties are here today. I wouldn't place emphasis on the numbers. It's more about the primary purpose. So to explain a little more, I cite two examples in the regulation, right? We have the definitions under B4, and then we have the regulation examples. And the regulation examples, it's on slide, involving example 4, involving Appliance and Formula Corp. There's also, the license agreement involves a right to manufacture and sell. So it sounds like, so there are two values here, manufacturing and the selling component, but yet the example concludes that the license pertains to a manufacturing intangible. That's because the intellectual property under the patent that's being licensed is required to create the appliances. So it's the same. That's why I use example 4 as an analogy to appellant's situation with the drugs. The drugs contain the humanized antibody technology. I don't think I've heard appellant agree to that statement. All past executive officers, descriptions in public filings like the SEC 10-Ks also confirm that the patent technology, the Queen patent technology, is used in the manufacture of these drugs. And so net sales, while the royalties are based on net sales, the sales are a measurement. It's a way to measure. It's actually a simple, I would say easy way to calculate the royalty income. So sales, net sales, or like an offer to sell, are just the right to sell is not determinative of the type of intangible. I don't know if that like helped clarify my response, or do you want me to explain a little more?
Yeah, I get that. Yeah, I get that argument. So you're saying it's not, you're not defining, you use the word incidental in your brief, so you're saying that FTB doesn't believe it's incidental, but kind of, you know, some sort of like the
So-
true like purpose, and there could be, one just has to be bigger than the other, a lot bigger than the other, or more, you know,
Yeah, so
important.
we focus, for the manufacturing intangible category, we focus on the predominant language. That's all we have in the regulation. And so today, you know, my presentation focused on the manufacturing value, and then our argument also, if there is a marketing value, you know, as claimed by appellant, it is still minor. It does not overcome the manufacturing value. Because Genentech is a manufacturer of these drugs. These drugs belong to Genentech, not PDL BioPharma. PDL BioPharma earns royalty income from sales, but that's just the way Genentech is able to make money on their drugs right there. It has to be a selling component.
Okay, and just on the towel example with the cartoon character, that's like an example of marketing. It's supposed to be an analogy of a marketing intangible. Just that example seems like interesting because, you know, if you have a towel, you would still like use the towel to dry yourself. Like it seems like even if there's a cartoon character on it, like there is value in the towel because, you know, so in that case, it seems, you know, maybe the towel has some value and the cartoon character has some value and the cartoon is a little more. But in that case, it's all marketing, not mixed.
So I can clarify. So I like this towel example, and I included it in my brief, and I discussed it today. And so this towel example is in the rulemaking files. It's not in the regulation examples. But we have it's a license involving the right to use a cartoon character. So let's say it's Winnie the Pooh, you know, on towels. And the conclusion is that the license involves a marketing intangible because the value really is in the Winnie the Pooh character and not the towel itself. The Winnie the Pooh character makes the towel more valuable to, you know, the consumers who are buying this towel. And I bring this up because even though appellant is not arguing a marketing intangible, they're arguing a mixed intangible. The marketing intangible rules still apply because the license agreement between appellant and Genentech don't separate the fees for the different components. So then we default to the marketing intangible rules. And so that's why I discuss this towel with the cartoon character for purposes of discussing marketing.
Okay, okay, thanks. Can I just ask the appellant a question too? And FTB was noting that the language that Genentech was given the rights to, you know, use, offer to sell and sell is, you know, basic patent infringement language, and appellants are saying that that's a shows that it was a marketing intangible. And I wonder if you could comment on it. Like, would that mean that every single patent would then be marketing because a lot of them would use that language, you know?
No, actually, but I'll start first, and I may turn to Mr. Stone to explain what the difference is. As Mr. Stone testified, there are actually manufacturing intangibles, you know, where even as it relates to a patent, right? So you could have a patent that just offers manufacturing rights, and but I do apologize, Judge Lambert. The first part of your statement, when you were referring to what respondent said, if you don't mind repeating that again, so I can address your question.
Yeah, in your briefs, you were talking about, you know, transferring the rights to import, use, offer to sell, and then FTB was quoting, you know, U.S. patent code, U.S. code 271, infringement of patent, that, you know, and stating that, you know, it's a basic language used that prevents someone else from, you know, manufacturing the product, and that's the purpose of it, and that it's, you know, common language, not necessarily related to making it a marketing intangible?
Oh, okay. Thank you for clarifying. I think I know what I think I know what you're referring to, because I actually noted it too. I know responded in their brief, as well as the presentation today, had said that offer to sell said, if I'm quoting, likely arose from patent law, likely arose. They have no authority. They're not saying it is. They have not pointed to anything that supports. Even their language is, you know, is very careful, because they can't say it is. Oh, sorry. They can't say it is. They said likely arose. So that is just not, you know, the offer to sell, it's basically that you're going to prevent somebody from selling it. If I may use an example, you know, I can say, here's a pen, I'm selling for $1, would you like to buy one? That is a form of marketing, right? I'm marketing my pen, my red pen. And so you know, that is offer to sell. Just like Genentech, when they offer to sell their drugs, Herceptin, let's just take that as an example. They're offering to sell, and the way they can get the doctors to prescribe it, as opposed to other drugs, would be to tout its safety, improved safety and efficacy of the drugs due to the underlying, you know, antibodies. So in terms of you know, the offer to sell, going back to, I think, your question, if I'm misunderstanding you, please correct me, is it is not simply preventing somebody from selling. You know, I think the FTB has not shown with evidence that that's what it says. You know, I know the FTB in its argument has said, you know, we're just making assertions, which is not true, and I'll get to that when it's our time to rebut. But, you know, FTB here is making a statement with no support. And so it is difficult for us to address a question when it's just a statement that they make.
Okay.
Oh, and I'm sorry, Judge Lambert. Mr. Stone would like to add something, if it's okay.
I'm hoping I can clarify a little bit. Yes, so the terms make, use, sell, and offer for sale are in 35 U.S.C. 271. They are the rights that the patentee has the right to exclude others. So whenever you have a patent and invention, you are entitled to prevent the making, having made, using, selling, or offering for sale. I think what we were trying to say, and what I was trying to say in my previous testimony, is that in this case, the offer for sale is by no means incidental. I mean, the offer for sale here is actually the entire value to Genentech in some ways. Certainly they need to make it. There's no question about that. And the patent would have prevented them from offering it for sale, as well as from making it. But I think your question of that, does that come from the statute, that is accurate. Those are the words of the statute.
And would this be something that's common to, you know, all these kinds of transactions, to include that language?
Many transactions would include all of the rights of the patent, because that's what you're licensing. There's certainly no shortage of patents out there they're solely manufacturer patents. There's also solely sale license. If I invented a drug and I don't have the means to market it, I would license out the means to market it, meaning the rights to sell and offer for sale. Same with manufacturing. If I invented a drug and don't have the means to manufacture it, I might license out the manufacturer rights, and then they would give me the drug, I would pay them for it, and then I would go out and sell it. So you can break these things up in any number of ways, including geographies and fields and all kinds of things, and that's what licensing attorneys do.
Okay, thanks. I don't have any more questions.
Back to respondent. Is it respondent's position that in order for a patent to convey marketing rights, there has to be in a license agreement for the conveyance of the patent, or the rights with respect to the patent? Is it respondent's position that that licensing agreement must also specifically refer to a trademark, a copyright, a service mark, or some other specified right that the respondents identified as a marketing intangible?
It is certainly the easiest and the most sure way to determine a mixed, like marketing value and a mixed intangible if the license agreement spells it out. And so we have, that's why I also discuss example 7. And that's in example 7 on slide 10 is about a mixed intangible. And it's really easy for the readers and, you know, anyone trying to figure out what type of intangible is at issue, because it says the license agreement specifies separate fees, which we know is not required for a mixed intangible. The fees don't have to be separately stated for the marketing versus the manufacturing components, but the fees are to be paid for. It's the right to produce the motor scooters. We have that here. It's the right to make the drugs using the Queen Patent's invention. And then also for the right to sell the scooters by marketing the fact the scooters were manufactured using the special technology. That's in the license agreement. It's very clear there's a marketing component, marketing value.
Doesn't that definition though presume the outcome of the question, which is they say it includes marketing, right? So it's like it defines the nature of its outcome, right? So my question though is, FTB's taken the position that in order for a patent to essentially convey, in the license of the patent to convey marketing rights, it has to say something like specific to a trademark, right, or a service mark or a copyright or something. Am I missing that?
I think it would be clear for FGB if that were the case, but, you know, we've asked appellant, you know, appellant has all these exhibits, like, I don't know, over 40 exhibits. These articles, they claim it's evidence of marketing.
Yeah.
So if these articles were produced by Genentech, and there's, you know, lots of evidence that Genentech went to doctors' offices, which had promotional materials of these drugs that discussed the humanized antibody invention by PDL BioPharma, then, you know, I think that could constitute evidence of marketing value. But in this case, we don't have that. We have third-party articles.
Fair enough. I was trying to get to the premise question, though, as to whether or not that right, that needs to be specified beyond reference to the sale. Is the FTB's position that in order for there to be a marketing intangible at issue, there must be in a licensing agreement specificity with respect to it being a trademark or a copyright or a service mark of some kind?
No, that is not our position, because that's not stated in the regulation. It's not stated in the definitions. It's a one method of proving marketing value.
For sure. Okay, thank you. I just wanted to make that clarification. So we get back to the question that I think Judge Lampert was getting at, which is what the definition of predominantly means. And you say primary, and which I think the respondent's position is primary means essentially more than half, right? Is that essentially the position? So if more than half of the rights conveyed represent the right to sell, the right to produce, if you will, or make, that constitutes predominantly a non-marketing manufacturing intangible. Do I get that right?
Yes, I think that's a
Perfect.
fairly accurate statement.
Okay. In the context of the reg says, let's see if I get this correctly. A non-marketing manufacturing intangible. This is subdivision 4B. I think it's 6B in the current reg. The value of the intangible property lies predominantly in its use in such process. So it's used in the process of manufacturing. If our premise is that a patent is essentially a protection from the right to sue, you may disagree with that, let me know if you do. How is it used in a manufacturing process? Is it simply the allowance of the right to do a thing, or does it have to convey some knowledge of how that process is to be conducted?
You know, I think it would have to depend on a case-by-case basis. But in this situation, you know, with the facts we have here with PDL BioPharma, I think both parties agree, and, we've gone over the language of the patent itself. PDL BioPharma had the rights, they owned the rights to the humanized antibody invention. And so Genentech entered into these license agreements to be able to manufacture and sell their drugs to cancer patients, food allergy patients, and these drugs contain the humanized antibodies. And so, that's the argument for the manufacturing component. Manufacturing is, as I argued, manufacturing involves a process. It's a process to produce a product. The product here is the drugs. The drugs contain the humanized antibodies as a component of the drug. So, I think it's hard to say that manufacturing is not involved here, just maybe to what extent. And our argument is it is predominant. If Genentech had the Cabilly patents, but the Cabilly patents belong to Genentech, first of all, not PDL, and those patents didn't result in the royalty income at issue in this case. So the content of the Cabilly patents did not result in the creation of the drugs that are mentioned on, I think, my second slide.
Great. Well, you bring up the Cabilly patent, then it wasn't that sort of the argument is that this particular patent at issue here didn't convey a knowledge, right? The FTB uses the word technology, but I guess it's in dispute whether or not they conveyed a specific technology that Genentech didn't already have possession of or didn't already have know-how how to do. That's why it gets back to my question, is the understanding of used in the process of manufacturing, what does that mean in the context of a patent? And does it require conveyance of knowledge, or is it simply the protection from suit means it's being used if part of that right is to make
Okay.
something?
Okay, thank you for clarifying
Yeah,
that.
of course.
So I'd like to point you to slide 5. Slides 4 and 5. And, I included all these quotes already in my brief, and these are public documents by former executive officers of appellant. And they talk about what the Queen Patents is. And so, on slide 5, to the left, we have the quote by Mark McDade. He says, the Queen Patents refers to methods and approaches by which you make substitutions to arrive at a humanized antibody. And he also discusses how PDL figures out that a manufacturer like Genentech has infringed on these patents. So they look at the sequence content. It's a protein sequence. So to the right of this slide, that's from the patent itself. And it's information for sequence ID number 2. I apologize if you cannot see it closely. It's the best I could do to get on this slide.
Understood. Fair enough. I appreciate the response. Okay. So that reflects the categorization question. And I'll ask you the correlated to what I asked the appellants, which is, let's assume if the panel makes the decision on the categorization that it's a mixed intangible. Under the regs, the mixed intangible, there's a presumption that the assignment mechanism is to the ultimate customer. Is it FTB's position that the lack of appellant's alleged evidence on ultimate customer means that we default back to the non-marketing manufacturing standards, or are we supposed to work off of what the best evidence is of that ultimate customer, or is FTB at all satisfied that in that circumstance, appellant's presentation on what constitutes a reasonable approximation is sufficient? Sorry, that was a compound question. I apologize. If you want me to clarify any of it, just let me know.
I'll try to answer, and if I don't answer everything, feel free to
Perfect.
follow.
Thank you.
So it is our position that appellant's reasonable approximation, if this license of the Queen Patents is a mixed intangible, is unacceptable. It doesn't follow the law. Because as I have a summary on slide 11 of the assignment rules. They're known as the cascading rules because they must be applied in the order provided. And so whether it's marketing, a manufacturing, or a mixed intangible, the first rule is to use a taxpayer's books and records. Reasonable approximation is a secondary rule if, for whatever reason, we cannot tell from like the license agreement or that who the ultimate customers are for a mixed intangible, or let's say the royalty statements don't evidence who the ultimate customers are. So my point I'm trying to make today is that appellant has only discussed reasonable approximation and using population. And it's not just California over US population, it's California over the population of all jurisdictions where they have patent protection. Even though it excludes China and India, it still includes countries like Brazil where the population is 200 million, similar to the US population.
Fair. So I understand the argument, but you're not answering my question. My question is, we've answered the categorization question. Just assume that, right? We've decided it's mixed. The reg creates a presumption that the assignment is based upon the ultimate customer. If the FTB's argument is that the appellants simply haven't established sufficient evidence as to what the ultimate customer is because they've decided to resort to reasonable approximation, what are we to do? Where the reg doesn't default this back to what the FTB's position is. It simply says the presumption is ultimate customer. So what are we supposed to do?
Well, first, I think appellant does have the data to figure out where their ultimate customers are, at least on a US basis. That is the license agreement section 3.08 spells it out explicitly, that Genentech had to give them information that contains like net sales by country. So if that's a possibility to figure out the net sales in the US and then use the California over US population, which at that time is about 12%. So it would be 12% of the US sales, and that would be assigned, that final number would be assigned to the sales factor numerator. And that would be a much more accurate, is much more reflective of the rules of reasonable approximation, because it's the appellant's burden to prove material use. The B7, I believe is B7, which defines reasonable approximation, says there is a presumption to use California over US population. As to, and so in my briefing, we didn't argue, FTB did not argue what would happen if OTA were to decide it's a mixed intangible in this case, and appellant's methodology, assignment methodology, is not sufficient.
Fair enough. I mean, I think part of your, in response to the appellant's argument, you seem to be arguing that they haven't established ultimate customer. And my question was simply, then what? Because it's not like the reg backs, at least as I read it, and I was curious about your guys' perspective, backs us out to some alternative, which would be non-marketing intangible, non-marketing manufacturing intangible, which is the FTB's position. So I understand the criticism. I was just trying to ask the next question, which is, now what? Okay, so, but I appreciate you answering my question. My last question would be somewhat of what I asked the appellant, which is, what was, when we moved from 4 factors to single sales factor, we picked up market sourcing and we picked up economic presence. What was the purpose of that, and how does that speak to how this reg is drafted with respect to intangibles?
So single sales factor is a result of the people of California passing Proposition 39. It's not an anomaly used by California. Lots of states use single sales factor. And single sales factor is, it's meant to reflect the market, right? It's meant to reflect a taxpayer's market. And so for purposes of these three intangible categories, then the question is, what is the market? And then, so under the mixed intangible rules, we look at ultimate customers. Under the manufacturing intangible rules, the customer is the licensee. It's Genentech. And it's where Genentech, we look at where did Genentech use the license of the Queen patents? Well, they used it to manufacture their drugs. And their manufacturing facilities, which appellant has never disputed, are all in California. So it does. So the rules do reflect the market. All three intangible category rules reflect the market. And so there is consistency there. I don't necessarily want to, right now, I'll say for rebuttal, I don't want to go into the 25137 argument yet. But the rules as they operate, as the way FTB assigned the receipts under the manufacturing intangible rules, reflect the market, and it's not, there's no like unfair reflection in this case. Does that answer your question?
It's responsive. Thank you. I really appreciate that. It's not an easy question, so that's the purpose of the question. Okay. Appellant, you have 15 minutes in reply. Just real quick, just to reset the table, 15 minutes. You guys get 15 minutes to rebut, and then they get 15 minutes to close because everyone wants to be here. This is a great discussion. Let's go.
All right, thank you, Judge Turner. So let me apologize ahead of time. I may be jumping around because I'm kind of just going with the arguments that respondent made in their presentation. So respondent argued, this is obviously for the primary issue about whether the license agreements were mixed intangibles. So as Judge Lambert said, the FTB's argument about predominant value, sorry, let me just move this closer, predominant value of the license agreement with Genentech. And, in FTB's presentation, they do say, it's primarily, predominantly, whichever word is used used for manufacturing rights. And so they said everything else, whatever there was, besides that, would be either minor, minimal, or inconsequential, as they said on their slide 8. And so this is just not true. With the facts, the license agreements, the testimony of Mr. Stone, the testimony of Dr. Holly Prentice. I know respondent has simply dismissed them, but they have not countered with their own expert testimony. They haven't countered with any kind of evidence. Declarations submitted under, penalty of perjury, and obviously over here with Mr. Stone, it is evidence. It is evidence, and so for a respondent to say we haven't supported any evidence to support our position is simply wrong. But also, just very quickly moving down the list, the respondent also said appellant's argument is that the manufacturing process needs to be improvements to the manufacturing process. And, but FTB's argument is that manufacturing simply means making a product using the IP in the patent. That just cannot be true. If that is the truth, then everything is a manufacturing process. Everything is a manufacturing intangible. But if you look at mixed intangible, it does say mixed intangible includes a patent. It's not trademark, it's not just all service marks, it includes a patent. So you have, I guess I want to say that, the respondent does make a lot of statements. They make assertions, and they don't support it with any authority. There is nothing in the regulation, nowhere in the law that says manufacturing is basically making a product using IP. As Judge Turner, you mentioned, in the regulation itself, it talks about the process, the manufacturing process. And in this case, the license agreement says to make or to be made, to offer to sell or to sell. There is nothing in the license agreement that talks about a manufacturing process. As Mr. Stone testified, For a manufacturing license agreement, you would think they would include it. Because if there's ever a fight about it later, how do you know what you're fighting about if it's never mentioned? And then in the patent itself, the Queen patent itself, manufacturer, the word is only used once. As Dr. Prentice said, she is an expert, in this field. She has done manufacturing process for biopharmaceutical companies and biotech companies, and she says, this is not it. The value proposition of the license agreement here is being able to market these as safer and more effective drugs. And again, this is a testimony made under penalty of perjury. So you have, and then, I would like to also then move to example 4. I know respondent relies on that quite heavily. First, I want to say, this example in the second paragraph on their slide 9, it's very interesting to me that it says, given these facts, it is presumed. It doesn't say why it is. It doesn't explain what it is. And it doesn't explain what the patent is. It doesn't explain anything. It just says it's presumed. It presumes away the question, right? When you presume away the question, how can you use that as an example that would support their position against what our patent clearly states? And not only that, my reading glasses, I like to point to, the part about, here we go. Regulation 25136-2 D2C. It says here that it requires that where a license of intangible property includes both a license of a marketing intangible and a license of a non-marketing or manufacturing intangible, the fees are not separately stated in this contract. It shall be presumed that the licensing fees are paid entirely for the license of a marketing intangible. Kind of what you mentioned, Judge Turner. And yet here we have example 4, license agreement whereby appliance is permitted to use a patent owned by Formula Corp to manufacture and sell. And the license agreement, and then so while here, I know the 2 does not explain it, but the D2C is about how you source. I agree. But my point here is you have here where the presumption is if you have 2, it's presumed to be marketing. And then here in example 4, you have 2, and they presume away the question that this is manufacturing. This example does not apply to our case because 1, it doesn't say what the patent is, and 2, it presumes away the question, I think. Yeah, and then example 3, I know, try to watch the time. Example 3, respondent argues that, in this case, she points to the second paragraph. This is slide 10, and it's underlined. The license agreement specifies separate fees to be paid for the right to produce the motor scooters and for the right to sell the scooters by marketing the fact that the scooters were manufactured using the special technology. And I think that goes to your question, Judge Turner, about whether it is required by law in the regulation that the patent must have this language in there, that they must say you can market this by doing X, Y, Z. It doesn't say that. The law does not require that. Nowhere in the law, and respondent can't point to anywhere in the law that says that. This is an example. This is an example where, again, it's different from us. You are talking about marketing motor scooters versus drugs for cancer treatment. Where on the drugs would you put the trademark? Herceptin is an intravenous drug for breast cancer. Where exactly would you put it? It doesn't make sense. And not only that, the FDA, if I'm correct, they strictly regulate what you can say and not say in the marketing of drugs. So example 7 is also not applicable to our situation. I think just going back to the whole idea that what's the value of these license agreements? The marketing value, despite what respondents said about it being consequential, minimal, minor, or it's dwarfed by the manufacturing, aspect of it. That is simply not true. Again, the testimony of both Dr. Hawley and Mr. Stone here today, and also in his declaration. And, respondent also said that the marketing cannot be evaluated in any way in a license agreement. That goes to the same question that I just mentioned a couple minutes ago. It doesn't require that. There's nothing in the law saying you must have that. So, the cartoon towel example, we look at Dr. Hawley's supplemental declaration. In response to that particular example, you will see, this is the last page of her declaration, which is on, it's paragraph 12. Here, it's a chart, so it's kind of hard for me to explain, but what she kind of compares the two and how, where it says the manufacturer and sale. So here, the manufacturer towels with cartoon characters for sale is what the end product is. The end product in our case is the manufactured pharmaceutical drugs with humanized antibodies for sale. So you have both, so we never said it is just marketing. We have never argued that, right? We have always said it's a mixed intangible. It is the respondent who has always argued it is manufacturing. And if I could, I know Mr. Vesely is going to address that, but I'm just going to very quickly say that, in terms of reasonable approximation, the information was provided to the FTB in 2019 during audit. The FTB, as respondent just admitted today, they never consider, well, what happens if it's a mixed intangible? So they never even entertained the idea that they could be wrong. And we provided information in 2019, 7 years ago. And here we are, now the FTB is asking, well, where's your proof? Where's your proof? Well, we provided lots of information back then. I'm not sure if they looked at the audit files. And in terms of, their books and records, while the agreement does say that they are supposed to provide, Genentech's supposed to provide information by country, I'm going to turn to Mr. Stone very quickly on that issue, like why we do not have sales information by country.
Yeah, just very quickly, we did receive royalty reports from them through my entire tenure at PDL, well, not the entire tenure, up through 2016. And the royalty reports did not specify country by country. That started before I got there. Presumably that was because the accounting departments got together and said, look, this is too troublesome and too burdensome. Can we just send you information relevant to our payment rights? So what they gave us was information about what was manufactured and sold in the U.S. versus what was manufactured or sold in the U.S. and manufactured and sold outside the U.S. because that was the royalty tiering. And so that's what we went with. So we don't have country by country data.
Okay, and then so last point before I turn to Mr. Vesely is I know as well that respondents said that the safety and efficacy issue is determined by the FDA, and that is not true. FDA determines a floor for safety, what's safe and effective for a drug to be marketed and sold to the public. They do not do a comparative analysis of drug A versus drug B and how safe drug A is compared to drug B and how much safer and how much more effective the two drugs are. So it is not true that the safety and efficacy of a drug, especially an innovative drug, is determined by the FDA. And therefore, as we said many times in the declarations and in testimony of Mr. Stone, is that it's the value here to Genentech is being able to market these drugs, saying how they are much safer and they are much more effective because of the queen antibodies. So I'm going to turn to Mr. Vesely.
Thank you. I just have a couple of items here. I really do want to emphasize a point that Ms. Wong just brought up, and that is there are a lot of assertions being made by the Franchise Tax Board, a lot of assertions without evidence. I would, again, I said it earlier, I would say, take a look at Dr. Prentice's 2 declarations. And here's a person that's testified under oath. She's an expert in the field. And she says the following: the predominant value of the Queen patents was not in its use in the manufacturing of pharmaceutical drugs. Rather, it was in its use in marketing the drugs based on the improvements of safety and efficacy of the humanized monoclonal antibodies covered by the Queen patents. That's evidence. They have no evidence on this point. All they're saying is, we think it's a manufacturing intangible. That's fine. I can say that too. I'm reading from an actual, evidence here, actual testimony. What is also evidence? What did the patent say? She also mentioned that. One time in the whole doggone patent, 339 pages, it mentions manufacturing processes. Nothing new. There's nothing new to the table here. These are the kinds of things that I think you've got to kind of weigh against what FTB is saying in this case, because they're just making assertions. And I think that's the part that makes this a little harder for you folks to have to understand this thing. The idea of predominant, as Judge Lambert was asking about, yeah, we've grappled with that today, no question. What does that mean? Under a mixed intangible, there's no predominant in there. It's a value in both of these 2 items, marketing as well as the manufacturing processes, not just the fact of something about some kind of a making of something. It has to be an improvement in that. That's what Dr. Prentice is talking about here. And I think that's the thing here, is that once we get over that hump, everything else kind of falls together, very nicely, that what PDL has done here, all the way to the reasonable approximation, is very consistent with the regulations. And what FTB is trying to do is basically read out this idea of a mixed intangible out of the regulations. Under their position, I don't think you'd ever find one as a mixed intangible. And I think that's the part here that is very troubling. That's what's given us a lot of time to think about how to best get this across. But the fact of the matter is, whether it's the mixed intangible issue, whether it's the reasonable approximation issue, whether it's ARP, whether it's the unfair apportionment issues, all of these things are all hinging on, hey, we think it's a manufacturing intangible. So therefore, you've got to have a penalty, because you didn't analyze it that way. Well, we analyze it very consistently what the law says. That's what's important. So that's all I have for right now. Thank you.
Wonderful.
Do I have a couple minutes? Or?
Couple minutes to get, I'll be
Very
patient, but
So on the AMT issue, I just want to say a couple things. I know I don't like it when if I somehow mischaracterize something, but I know respondent said that they never said this about NASCO, but in their supplemental reply brief, they actually did say that the NASCO decision, the FTB, I mean not the FTB, the BOE did not have. The BOE provided no justification for its determination that tax includes AMT for purposes of subdivision D. And the fact is that's not, this is straight from their brief. They do not think that the BOE, the SBE, provide any justification for why that they think there is ambiguity. And I like to point out that certainly the language of the statute is not as clean or as unambiguous as they say it is. And, sorry, reading glasses. So I like to point to 23036. This is under I2. Here, here's the statute, right? The legislature actually they know how to write what they mean by regular tax. Here it says, I'm just not reading the whole thing because it's a long paragraph. It says, limited to an amount equal to the excess of taxpayers' regular tax, as defined in section 23.455, determined by including income attributable to a disregarded business entity that generated the credit or credit carryable over the taxpayer's regular tax, paren, as defined in section 23-455, end paren. So they say this 2 more times in this subparagraph here. So clearly, the legislature knows how to define regular tax as well. So as for the point that, that respondent has simply, used selective legislative history, that is not true. I mean, we could go through the entire time, but I don't think we have time to go through all of them. Selective because they're representative. Respondent did the same thing. So, I don't think that is something that could be, appellant could be faulted with. As for ambiguity, ambiguity is there, I'll wrap up. Ambiguity is there because, well, reasonable people can disagree, right? And I think the SBE, according to Citibank, Citicorp case, where the SBE's expertise cannot be doubted, their determination that there is ambiguity in the word tax means that FTB is not 100% correct, that they're not the only definition that is correct, that another person, another tax agency could find ambiguity in the word, just like many other taxpayers have found ambiguity in the word. And so then you look to legislative history. And so and then one last thing, policy-wise, there is a policy about how the AMT was first put in place to make sure everybody pays something. That is correct, but the legislature has also found that some of the credits listed under D1 are of such overriding importance that they are going to overlook that general rule that you cannot use credits to lower your AMT. So I will end it here, and thank you.
I'm going to hold questions, if that's okay, until we're all done. We've got one more here, one more there, and then we're going to have maybe some questions then, okay? Just in the expediency of time and the indulgence of our audience. So respond in 15 minutes.
Thank you. So, appellant, first I'd like to talk about the declaration by Ms. Holly Prentice, which I didn't include in my presentation earlier. So I talk about this declaration and why it's not persuasive at length in my reply brief. So I'm just going to keep it short here, but Ms. Holly Prentice, while she has, great credentials, no one's arguing that, her declaration is not persuasive to the issue in this appeal. She was never an employee of appellants. And additionally, in my briefing, I explained why her statements are contradictory with the statements in appellant's own SEC filings and those made by its past executive officers. I included those statements on the slides. They're also in my briefs. And so, respondent would request that very little weight be given to her declaration. Next, for mixed intangible categorization, appellant has to prove that there's value in both marketing and manufacturing. I don't hear them disputing the manufacturing value. They, as we've both discussed, the license agreement, the language to make, have made, that refers to manufacturing, and Mr. Christopher Stone said the same when I cross-examined him. So there is manufacturing value. Genentech made these drugs using the Queen Patents technology, the humanized antibodies. The question then is, where is the marketing value? What proof has appellant provided? We don't have promotional materials of Genentech going to doctors' offices discussing how superior these drugs are because of the humanized antibody invention. We have third-party articles, hundreds of pages of them, journal articles, third-party, but these are all third-party and these are opinion pieces. They're not evidence of a marketing value. So then what we have is the examples. We have the regulation definition under B4 of the intangible categories, and we have the examples. So my argument is the examples are very important. The examples are meant to guide and instruct us on how to classify the different intangibles. And so I heard Ms. Huang say, you know, example 4 doesn't apply to them. Example 7 doesn't apply to them. Then what example applies to their situation? The regulation has several examples of a mixed intangible, but those examples involve a clear marketing value and proof that there's marketing value, that PDL BioPharma earned royalty income from some sort of marketing value to its licensee. In this case, we simply do not have that. Next, I'd like to also move on to now the reasonable approximation. Appellant said they gave us this exhibit in 2019. We've had this exhibit. The problem is the exhibit is a calculation. The exhibit does not show us where the ultimate customers are in any of these jurisdictions, or where, like, if appellant actually sold Xolair and Lucentis and Perjeta to Brazil. We don't know that. All their exhibit shows is the population of these countries. That's not evidence of material use of this license. So, you know, it's really not acceptable. It's not an acceptable, reasonable approximation for FTB. If appellant's main argument I'm hearing today, and it's also in the briefing, is that the marketing value is from the offer to sell and sell language in the license grant. The license grant clause does contain that language, but we've discussed it's standard language under federal patent infringement law. Does this language actually mean that appellant marketed to doctors these drugs, that they manufactured these drugs using the Queen Patents technology? No, there's just no evidence of that. And so, while, you know, if there were evidence of marketing value, I think we could reach the mixed intangible category. And so that's what really this whole dispute is about. We just don't have the evidence. On respondent's side, our burden is to prove predominance. Was a predominant value in manufacturing? I don't think anyone here could argue that Genentech didn't manufacture these drugs that contain the humanized antibodies. Genentech created these drugs. They belong to Genentech. They're very lucrative drugs. They resulted in almost $500 million in royalty income during each year at issue. But if these drugs weren't manufactured, if they weren't created, there would be no sales. The royalty income would not exist. Finally, I'd like to touch upon the appellant's section 25137 argument. Appellant focuses heavily on this 57% to 100% number, but it's actually very misleading. The sales factor in this case for all 3 years is between 39 to 47%. There are receipts other than royalty receipts in the sales factor numerator. And FTB already started at a subset of that $500 million in royalty income. FTB excluded approximately 20% already. FTB only wanted to focus on the royalties from Genentech. And so, you know, I would just like to bring to the panel's attention that section 25137, the first inquiry is whether the standard formula is a fair representation of the taxpayer's business activity in this state. It is. Appellant entering license agreements with Genentech. Genentech manufactured these drugs. The royalty income is a result of drug sales. We, respondent, applied the rules. The 57 to 100% is based on, we looked at each drug individually. There are 6 of them, and we looked at each of them. Also, all the determinations in the prior tax years, I already said it once, but I'll say it again. It was a different tax regime. Different rules applied, and that drove the outcomes. I think so. In conclusion, respondent has proven that the predominant value of the license of the Queen Patents is in manufacturing the drugs using the humanized antibody technology owned by appellant. Thank you, that's it from me. And Mr. Miller? Okay. We're done.
Thank you. All right. Appellant, get a close. 15 minutes, if you want to use it all. And then we may have some questions, we may not.
I'll trying to take up too much of the panel's time. So I just want to address what respondent just said now about how Dr. Prentice's declaration should not be given much weight because she was an employee of appellants. I don't think there's any requirement that declarations, made under penalty of perjury need to be working for a company that it's for. That's why she's an expert witness. This is her expert testimony. And the other point is that, respondent said that her statements were contradictory to SEC filings, and respondent points to the quotes. But if we look at the quotes a little more carefully, this is, I believe, pardon me while I search, one of the ones that respondent made was on page 5 about the CEO, Mark McDade, what he said. And what he said was the Queen patents refer to methods and approaches by which you make substitutions to arrive at a so-called humanized antibody. That does not contradict what Dr. Prentice said. Dr. Prentice said that the value was not in manufacturing. The value was in the marketing, the Genentech's ability to market and sell these antibody drugs based on the safety and efficacy of the underlying Queen antibodies. The quote here on slide 5 does not contradict that. There's nothing here that says, nope, that's not true. So I'm not quite sure why respondent thinks this is the end all and be all to that question. And also in terms of the mixed intangible, we have said too many times already today that this is a mixed intangible because you have the offer to sell and to sell language. And as we've discussed also many times today, the regulation does not require a certain level of marketing activities. It also doesn't exclude a certain level of marketing activities. In fact, going back to the Chief Counsel ruling, only for the purpose of the definition, Oxford definition used by the Chief Counsel, that's all we're using it for, is that marketing is defined as the action or business of promoting and selling products or services, including market research and advertising. These are drugs. Drugs are not marketed in any way similar to motor scooters or appliances. They're just not, and I think everybody here understands that. So to require basically you to say, hey, the PDL name or the Queen patents need to be somehow fixed to the drugs that Genentech sells, and that will be marketing. That is just ridiculous because drugs are simply not marketed that way. And then also, respondent just said that, well, we don't have promotional docs from Genentech to show that they were promoting it, they're selling it, they're marketing these drugs. Again, the regulation doesn't require that. And it is interesting to us that this is the first time in 7-8 years, starting with the audit, that respondent is saying that if we have marketing value experience, then perhaps they will consider mixed intangibles. All throughout the audit, all throughout the protest, all throughout this appeal, as evidence in their briefs, they have been insistently and consistently and persistently saying that these were manufacturing intangibles, never allowing for any kind of possibility that there was marketing aspect of it, despite the language in the license agreement. And so, respondent lastly said that if Genentech didn't manufacture these antibodies, then the royalty income would not exist. Well, I would say this. If Genentech did not sell the antibodies, the royalty income would not exist. So I would end it with that, and I think I'll turn to Mr. Vesely for the other points.
I will make this short. I think that there's a few things here, just to follow up what Ms. Wong said. It's interesting, Ms. Wingert was just talking about the reasonable approximation concept, and that we didn't provide any evidence about who are the ultimate customers. Well, that's the whole point of the reasonable approximation. You don't have that info. Mr. Stone has testified that we don't have which customers there were within these various countries. We have the countries. And that's exactly all the regulation talks about. It doesn't talk about having, being able to pinpoint what customers bought this or not. It's a matter of if they're sold into that particular country, and that is what we're trying to do is approximate to get to what should be a California royalty-sourced income here. And so the fact that we didn't provide info about the ultimate customer, well, that's why there's an approximation. The other part here is that we cannot lose sight of the fact that their position is to talk about the manufacturing intangible, and they have to show that the predominant value was in that. And they have to show that the predominant value in the license agreements with evidence was in manufacturing. We have shown the opposite through Dr. Prentice. We have shown it through the patent language itself. So the bottom line is that what are the facts? What is the evidence that shows predominant value or not? And I think they have not done that. They have not shown that at all. The other part about saying sourcing, and using Genentech being in California, and the idea of unfair apportionment here. Well, yeah, they're in California, no question about it. But the fact of the matter is they didn't generate any income unless they sold those drugs overseas, wherever they sold them here. That's what's important here. That's the aspect. That's what makes this a mixed intangible. That's what makes it the question about fair apportionment. I mean, the interesting part about the other argument is about different tax years. Yeah, we all know that. Different tax years, they stand on their own. But what doesn't stand on its own here is that are you fairly representing the business activities of the taxpayer by your methodology here? And we would assert, no way, that doesn't happen. That's why the prior years are important to put this in perspective. That's why the prior years are important to put the penalty in perspective here. The fact of the matter is, those are Genentech's activities in California. PDL's activities in California was providing a license to Genentech there. And, you know, there's nothing here of PDL's activities that would put you at a level that whatever percentage we're going to use here, the 56 to 100, 35 or 40, whatever it is, it's wildly out of line here. That's the problem here. And I guess the last thing I would say is the examples that are in the regulations are just that. They're examples. They are not the actual substantive part of the regulation. And I think there's no two ways about it. What Ms. Wong said about example 4 and 7, those do not help FTB in this case, frankly. And I think that the fact is you got to read the language of the license agreement and read the evidence that actually has been presented. Read the patent itself, as painful as 339 pages can be. Read it. You'll see that there is nothing about manufacturing in there other than one time. We appreciate the panel's time on all of this, and we have any questions, please feel free. Like that.
I'll open up to my panel. Judge Hosey.
Thank you both for your presentations. I have no further questions. I really appreciate your time and effort on this one. It's been tough.
Judge Lambert.
I don't have any questions. Thanks.
I think I'm good. Thank you all for this great presentation and discussion today. Very informative, very helpful. With that, we will bring our hearing to a close. We will close the record. We will take this matter under advisement and render an opinion within 100 days of today's closing. And with that, we're done. Our hearings for the day, we are adjourned. for the day. I sometimes miss my processes. Yeah, with that, we're good. Thank you all for participating today.
Thank you, Your Honor.
Yeah, safe